Hello, everybody. It is Artie of Artie's Corporate Fiction. How you guys doing? Welcome to the stream. I don't know why the music wasn't playing, but it is what it is. I'll have to fix that later. We have a very special stream for you. This is going to be covering the latest in the Lane Myers saga. Just to give a quick overview of who Lane Myers is and why we're covering him. Lane Myers is a very special individual out of Arizona who has who believes he was wronged. If I'm going to try my best to summarize. At some point, he was charged with some offense that I can't recall. Recall. He the charges that were either dismissed or he beat the charges. I can't recall which. But since then, he's had it in for the prosecutor of that case. Thereafter, Lane Myers got the idea that the prosecutor's wife got his wife fired from her legal position. And since then, Lane Myers has had an absolute vendetta against the wife. The wife works as a public employee with I can't remember if it's Arizona State or Arizona. What? Oh my god. Oh god, call it college. Okay. I'm sorry. U of A, forgive me. I didn't realize I committed a cardinal sin. She is a public employee with the University of Arizona. And Lane Myers also happens to have a fairly decently sized YouTube channel. And as you might guess, he has utilized his YouTube channel and his followers to conduct what I think, in my opinion, is a harassment campaign against the prosecutor's wife. Basically going live with these 6-hour, 7-hour, 10-hour unhinged live stream rants where he calls her every name under the sun and also displays her contact information with University of Arizona. Naturally, this causes his sycophants to call in and say some really disgusting things, which resulted in him getting hooked up for harassment. Apparently, that wasn't enough for him because he continued to pull this bullshit while he was out on bond, leading to additional charges being levied against him. So he has 2 different cases against him involving harassment. So that's where we're at. Recently, he was denied bond, so he's currently in the custody of the Department of Corrections. In his first case, he has won his right to represent himself. He has not yet done so with his second case, and so that's why when you listen to the hearing, you're going to hear Lane speak, but also his counsel speak. When the counsel's speaking, that's when you know that they're referring to this matters involving the second case. So the hearing that was held, I think, was it Monday, 2 days ago, involved one. It was a media request, I guess, for both hearings, Judy. Okay, so media request for both for both cases, I should say, and the second one was involved at the very least a motion to dismiss, but I think there's other matters that are being heard as well. And Judy is here with me today because Judy apparently had a front row seat to not only the hearings themselves, but apparently some shenanigans that happened outside of the courtroom. And she's going to give us all the tea and insider knowledge. So Judy, welcome. I'm gonna switch it up so you can see her, and yeah, say hi. So. Wait, wait, hold on, Judy. She's no, they said that you're, they can't, I can hear you, but they can't. Hold on. I don't know why. 1 second. Yeah, I can hear you, but they can't. Give me 1 second, I'm sorry. Nope. Here, and then Discord. Say something? Nope. Nope. No. Why is it not going through? I know. Say something now. No. Uh-uh. Oh, shoot. Let me just... Why is it that I can hear you, but they can't? I don't understand. 1 second. Oh, no. Oh, maybe I have to do... No. It's on my end. Like, I can hear you perfectly fine. It's just I need to figure out how to get Discord's sounds through into OBS. And then where is it? Discord. So that should be fine. You should be able to hear you. I don't get it. Why the hell can they not hear you? You can try exiting and coming back in. I just don't, yeah. I don't understand. Yep. Check the capture settings. The OBS capture the Discord chat needs to include the audio. Oh! Hold on. Let me see if that does it. Discord voice overlay, Discord capture. Oh. Say something now. Oh, wait. Hold on. Almost. We're almost there. I think I got this. Thank you. Thank you, Tones. Oh, wait. Was it this problem the whole time? Hang on. Wavelength stream. Now say something.
How about now?
There we go. Okay. We're good. Finally.
We figured it out. I figured out nothing. Already did it all. Oh.
All right.
Probably my overlay looks weird.
Okay. I'm sorry about that. Okay. Reintroduce yourself. Go for it.
Okay. I don't know why. Oh, there we go. Okay. Hi, I'm Judy. You got this. I live in Tucson, which is right where Lane Myers is. And someone on another channel, Jim Finch from Really Cool News, said, "Hey, if you have an afternoon free, there's something I'd really just. They only stream audio. Could you maybe get some eyes on it?" And I said, "Oh, well, my schedule is open. Yeah, let me go." Oh my gosh, I had no clue who Lane Myers was, and the shenanigans that surround him. So I went first to hear. I think it was a bond hearing. I think it was the first one that I went to. This at the end of March. And I'm like, what is this? Who is this? What is going on? And I have been hooked ever since. And half the fun happens before the judge takes the bench, which means before the audio kicks in, or in the hallways, which of course are not covered either. So I have my trusty little notebook because of all the shenanigans, no phones are allowed in the courtroom, at least that are on. And that was a vast majority of the fun that happened on Monday. Had to do with the phones. So it's fun, it's never a dull moment, and I am now hooked. So happy to spill the tea for you on just what's going on.
Okay, so with that being said, what is so Mike Brown, is it Mike Brown or Michael? Mike, it doesn't matter.
I think it's Mark Brown.
Mark Brown, thank you. He I guess set us up for the shenanigans. This is prior to the media hearing. Mark Brown, I guess he's obviously a YouTuber, and
he wants to be. He has a laminated badge, Artie. It's laminated. Of course he does. It hangs around his neck. So, and he has a clipboard full of lots of very important looking papers that he shuffles through constantly. So he's very official. He's very official.
Take me seriously, damn it.
Yeah. So I got there a little bit early, and I had seen Mark Brown before at a hearing because he's very tall. You can pick him out a mile away. He had two gentlemen with him this time that I did not recognize. Funnily enough, Mr. Parvin, Mr. Myers' advisory counsel, did recognize one of the other gentlemen and said, "Hey, don't I represent you for an appellate matter?" Which is always a good way to start off. The guy had no clue. He had absolutely no clue if Parvin was his attorney or not. But Parvin instantly is aware of conflict of interest now. So that was interesting. The rule is when you go into Judge Metcalf's courtroom, there's a sign on the door that says no audio or visual or video recording allowed. And like I said, they're all audio broadcast. So you can definitely tell, you can hear what's going on. Mm-hmm. The gentleman that has apparently has Mr. Parvin as his appellate attorney had his phone out on his leg as he was sitting down with earbuds going up to his ear. It was a lovely pink phone. Think Hello Kitty pink. It was adorable. And he was not happy when he was told by a CO to put it away. And he seemed to be very jumpy around any police or corrections officers. He didn't like them approaching him. He didn't like them talking to him. He literally closed his eyes and went like this. So that if I can't see you, you can't see me. Okay, except that, yes, they can. There's one other gentleman who was wearing a hat coming in and had to be told a couple different times, take it off. And he had his phone in his chest pocket with the camera lenses pointed out.
Visible, naturally. Yeah.
Of course. He was asked to put it in his pocket. He said, "Nah, my pockets are full." Okay. Besides that, I don't have a case for it and I don't want to break the phone. Okay. So turn your phone upside down so that the camera lenses are inside the pocket. What are you going to do next? Tell me to turn my pants inside out? Which I thought was a little bit of a leap. I didn't see that as the next step. But maybe I'm missing something. I could be missing something. So that was with the one sheriff and the one corrections officer. A woman who identified herself as a bailiff. She didn't have any of the gear, but maybe I don't know. I could have sworn I heard I could have sworn I heard her identify as a bailiff. She was the one making the demands that phones be put away. The guy with the phone in his chest pocket started shushing people. I wasn't sure at first if he was trying to shush his friends. His friends became quiet. He then was shushing the bailiff. You can guess how well that went.
Of course.
'Cause no. So she very calmly walked to the front of the courtroom into one of the little passages. And within a minute, there are now 6 COs and sheriff personnel, the courtroom security staff that have they like wear black shirts and their badges are like embroidered on. So my take from that was that they could go hands-on and not worry about a badge falling off or being taken off or being used, scraping anybody up if it's sewn on. So they struck me as the type that they were ready to go hands-on if necessary. So now we have lots more COs and, much larger presence in the room. Initially, the man with the adorable pink phone was 1 seat away from me. When all these folks started coming in, I was like, I think I want a little more space between us. I want to breathe a little. I want to take some nice deep breaths. So I moved to the end of the row because I had been in the middle. So now I moved to the end. The sergeant of the COs walks right up to pink phone guy. And, they start talking right away. Oh, well, of course, they're asking for badge numbers.
I'm assuming all this is happening inside the courtroom itself.
Inside the courtroom before the judges has arrived, yes.
Gotcha.
They want names and badge numbers, of course, which the COs are happily giving. You're interfering with judicial proceedings. And just, I mean, again, they're just like closing their eyes, like, we're not disturbing the court. You guys are out of bounds. Well, that's going to go well. So, and now we also have more sheriffs actually entering as well. They say the phones must be off. That is the rule for Judge Metcalf's courtroom. The phones must be off. And you will be trespassed from the courthouse if you do not obey, if you do not comply. So I am getting ready to move against the wall because the COs are looking like they may have to go hands-on. If they are, because now they're impeding the judicial proceedings here. You're a tyrant. I was like, bingo. Where's my bingo card? You're a tyrant. You're outside your bounds. Color of law. I just in my mind I was checking them all off on the bingo card. That they're swearing at the bailiffs or at the COs. They're just absolutely trying to stir it up. Mark Brown is trying to get the COs to read his paperwork as to why he needs to be filming this now. The COs are like, we're dealing with something else right now. Do you mind? Finally, all of them put their phones away. So, and once they are sure they are all either away or off, then the motion is called and the judge comes to the bench.
Okay.
But that was a good 15 minutes, I'm going to say, of going back and forth. It seemed like 3 hours because, of course, I'm a wuss and I don't tend to get involved in things like that. So, and while Mark Brown did rise for the judge, the other 2 gentlemen did not. Of course. So then Mr. Brown sat down and started to plead his motion, and Judge Metcalf,
we can basically hear the motion here right now. I think I started right when
request
jumps in.
And the judge is pulling books off of his shelf to make sure that he is reading the correct procedural stuff along the way.
I don't know if the other case is also here where Mr. Myers represents himself.
No, we're only here on cameras in the courtroom for the 1454 case. So before I hear on the motion, I will note that I found that any personal audio recorders are obtrusive, distracting, and otherwise prohibited in this case, as with the earlier case. So I'm ordering that no personal audio recorders be used during this proceeding. Anyone who attempts to record this proceeding in the courtroom or otherwise be disruptive, I'll order the COs to remove that person from the courtroom. All right. We have a motion or request from Mark Brown. Are you Mark Brown, sir?
Yes, sir.
Okay. Let's have Mr. Brown come up right over here in the corner where that microphone is. Then we could pick you up well. So you sit right there in the jury box in that corner. Yeah, you just have a seat right there. That microphone's hot, so you can we can hear you well. Okay.
Trust me, I love.
Ah, that's why.
So, Mr. Brown, you've asked.
Yes, sir. Yes, Your Honor, I do.
All right. Why do you want to record these proceedings?
For transparency, and I got it. I've been doing this for 6 years now, and I got a ruling on that. I'm going to. Can I approach the bench?
Give it to my bailiff, and she'll give it to me.
Okay. See how many copies I need here. So here's one for the judge, and here's one to.
Mark Brown is sitting on a half dozen charges himself. Oh, really, Dummy?
Page 2 got
Wow.
missing. I was trying to find it by this number. You can look that up. This is Judge Gordon's ruling.
I have page 2 on here.
Okay, that at the bottom, that page 2 is a mix-up. If you look, that's the rules for. That's page 2 of the rules on 50-4 at the city court. So yeah, so that all that the page 2 is not part of this. That's my mistake.
Okay.
So stipulate. But if you go to this, it's December 6th or 26th of 2018, case C201. So if you go to there, you'll get page 2, but all the rest of it is accurate.
Okay.
It's just so you know. So anyway, and page 7 is the one that page 7 is where that's this case. Just a little brief thing on it. I had injunction of harassment just like him at city court, 3 of them. Okay. The first one was,
Of course he does.
I went to court and lost on justice court, and then it went to you. And you, the second one, the first one you ruled on, and you threw it out, not on the merits.
Me or somebody? I don't think that was my case.
Is there another Metcalf in this
No,
court?
no, only me. I don't recall that case.
In 2019, it's a long time ago.
Okay.
So it
Oh,
was
wow.
2018
Okay,
or 19,
sorry.
right at the end of 18 or the beginning of 19. So I had 3 of them, and it's the same thing. It was with public officials just about this case, and in that case, I appealed it because they said I had to get permission from the judge, like they are now on 122H. Well, when I was under the injunction, I had to follow all the rules. Well, 122H allowed me to tell the judge that I was going to audio record, and I didn't need permission. All I just had to do is notify him in advance. So I did that, and they said I couldn't do that. While I was under that injunction, I had to listen to their injunction. It says I couldn't do that. Then once I put the appeal in, argument number 2 on page 7, I'm going to read this real quick. So argument number 2 is on this case. Okay, Brown argues that the Pima County Justice Court misread rules 122 and 122.1, and they're still doing it. Okay, so reply, Brown argues that the Pima County Justice Court misread rules 122 and 122.1 to the extent that the Pima County Justice Court read the rules 122 and 122.1 to require Brown to get judicial permission before recording outside the courtroom in the courthouse, and to always get judicial permission before using a personal audio recording inside the courtroom. The court agrees with Brown, okay? And then it goes on to say, the injunction incorrectly states that Rule 122 requires Brown to secure judicial permission to film outside the courtroom and in the courthouse, and potentially overlooks 122H. And that's what I've been saying all along. 122H, I just have to notify you I'm going to be audio broadcasting even. Back then, I was just audio recording. I wasn't broadcasting. Then it goes on to say, the limited exception for this rule, the personal audio recorder in the courtroom, the court therefore will remand the case back to Pima County Justice Court so the injunction can be modified to reflect a correct or more clear reading. So it went back to the court. Then they said I just had to notify. So when I was under the injunction, I was able to do that. And then they came out with these administrative orders that said everyone else couldn't. I could do it and everybody else couldn't because I had an order to, but everyone else should be able to because they have to read 122.
So, but in this case, are you acting as a member of the press, or are you just here
Yes.
on? Okay,
I'm
so
a member of the press. I'm
Okay, so
Arizona
that-
United News.
that's a different rule.
Arizona
that,
United News,
The
okay.
normal 122 procedures
Yeah,
apply.
but I'm doing it under, I'm doing it under C. And then at the end of this on 122, it says, under 122D, it says, file or limit of coverage. A properly submitted request for coverage, and I put in a property request, should generally be approved. But the judge may deny or limit the request as provided in this paragraph. A judge's decision on the coverage request or objectivity to a coverage is.
Real quick. So I think what he just wasted everybody's time with that initial argument, with that initial bit, because it sounded like 122H, where he says all I need to do is just notify you. That's for the party. That's for a party member, not for a member of the press. Now he's talking about 122. That's why the judge asked, "Are you coming in here as a party member or as a member of the press?" And that's why 122D applies.
Reversible only by special action. I was going to do a special action, but as you know, I'm the one that put in. I went to the federal court. I filed it last week. I don't know if you got it yet, but that's me also. I'm trying to get my rights restored in the courtroom and to keep what happened in here before you came in. All these guys surrounded us. It made it hard for me to concentrate on what I was trying to do because all these guys surrounded me and telling me to do something.
I told the officers that.
That's a reference to what happened
until we had the hearing.
Yes, and I'm not recording.
Okay.
But and I also got this order from you that says I can't. You put that order on me and it says I can't. So that's why I'm not. Last time I was here, they wouldn't let me in the courthouse. They made me surrender their phones to them to enter the courthouse. And that's prior restraint. I'm a.
Hold on. No one's doing a prior restraint. That's when you can't say what you want to say. No one's ordering that. The courtroom itself is open, and you can sit here if you behave.
Yeah.
And listen. The question is whether you can record either audio or.
Yeah, I always hate it. I always hate it when they try to make this prior restraint argument. It's not prior restraint.
Yeah. And you are allowed to be in there with pen and paper.
You can be there, take pen and paper, taking notes. Yeah.
Visual. That's not a prior restraint.
Well, I can't. Like I said, by the rule you just read, 122H allows me just to.
Oh, and I remember this. I'm sorry, real quick. What's his face? Rogue Nation. This dumbass. Says, well, my form of journalism is as a videographer, man. Shut the fuck up. Just, you know how to read and write.
To notify you, but if he makes
or at least you ought to.
Everyone that wants to do 122H can't. All they have to do is notify you or your staff, And when I was going through this, they gave me these blown up rules. Dick Tracy and Anna Meadows, and they gave me all these blown up things. And I said, great, can you guys read it and follow it? Because them guys can't make everybody turn their phone off.
Yeah, hold on. I have control over the courtroom, and I can order things to make sure that the proceedings happen respectfully and quietly and with dignity. And if there are people here in the courtroom causing a disruption with recording, that is not consistent with that. And so I have the absolute authority to deny anyone the right to record anything.
But I wasn't. No one was making it. No, we just said
there's been a lot of chaos involved in this case. Unusual amounts.
From the prosecution, I got it, but
no,
it wasn't me.
Prosecution, no.
Oh, well, try to sneak that in.
It never was, and that's the problem.
Why do you want to record it?
I want to record for transparency because last time when Anna Meadows told me that morning on that last hearing, because you approved it the day before, I thought, great, a judge that was really standing up for us, and then I could sit at home and watch it on my TV. I'd rather be at home. If you would have put it up like you said you was going to put the audio and video up there, then you came on the 15th, I think it was, and then reneged on it. So that I was at home. I was going to rush here, but I couldn't get here in time, and I wanted to see. Everything. And when I was listening to it on the audio, you kept saying to Lane Myers that he was being threatening you because the way he was looking at you. Well, I wasn't here to see that. I wish I was in there to see if that was happening because you can't see that over the audio. And then that's why I would like to be here, and I would like to audio and video record. And the other courts always let me. The city court lets me do just the judge. I put my gimbal up here and put it just on the judge. He won't. And then the other places on this court, they let me record anywhere. In Justice Court, I did it several times. I do my own case. I did it dozens of times. This is the only time someone ever told me I couldn't do 122H since I had this injunction and before I appealed it. But before then, I couldn't do 122H.
Okay.
But I should be able to walk into the courtroom and tell your staff that I'm going to be audio broadcasting. I know I can't turn it on until you're on the bench because it says in there that you can't do it when the judge is on the bench. I've been going over 122.1 for 6 years. I've been in jail 4 times for it, and.
I mean, yes, touche. Ben Franklin needed audio and video to record when he was a reporter. I mean, how else was he going to dictate his findings?
I've never been convicted of it, but I've been harassed by security especially Dick Tracy and Mary Jane. You know, I was in an arm cast for a month and a half because of Mary Jane, what she did to me in justice court. And in justice court's even different because they got common areas that you don't have to go through security. You can go to the treasurer. You don't have to follow 122. In the rules of 122 in the courthouse, it says that when a courthouse is used for other things like justice court is. But I still was attacked by the security from this court. They come over there too, Mary Jane and Dick Tracy both. And I'm just trying to get my rights to record so I can find out what's happening here. And I don't got to rely on somebody else telling me that was sitting here. Their memory, my memory's bad. You know, I like to go home at night and I can't hear very good. You know, I'm a disabled veteran with hearing problems. I like to go home at night, turn my stereo up and listen and watch. You know, and watch it. I like to see the body. I would have liked to seen what Lane Myers was doing to you, staring you down or whatever. I would have liked to see that to see if that was true because I didn't hear any threats. And you kept saying that he was threatening you. And I didn't hear it, but then you went on to say that he's looking you down and he's doing other things. I would just like to be here to witness that. And if you would,
Well, you can be in the courtroom to witness it.
yes,
You can
I know.
be.
But what I'm saying is I was going to do
Yeah,
it from
true,
home. 'Cause you said that you was
true.
going to broadcast the audio and video. And if you would do that, I wouldn't have a problem here. I would go home right now if you broadcast this one at 3 o'clock to everybody. And the two people you denied, the Phoenix Times and RP, let them do it too. If they have the link, they should be able to do it, and anyone should be able to watch it live. And if they would do that, I wouldn't have no problem. Transparency is my main issue.
Okay.
I want to be transparent. I don't want to have to drive down here and pay your parking meters and go out there every 2 hours and feed the meter. You know,
Okay.
I would rather sit at home
Which,
and watch it. So
by
if
the
you
way-
was to say that you're going to broadcast the one at 3 o'clock.
The parking is a bunch of bull because you can't feed a meter with coins. It's all on an app. So all you
Well,
got to do is
Yeah, I would.
punch it up on your phone.
Yeah. I was gonna say, yeah, I don't know of many cities who still run coin operated. Maybe they do somewhere, but I feel like the vast majority have all switched to the apps.
Yeah.
So
Tucson is all app, and the city court definitely does things different than the superior court. Different building, different personnel, whole different way of doing stuff.
right.
O'clock, I'll go home, we'll forget about this, and then Phoenix Times can do it, RP can do it, anyone else, they don't even have to be here to watch it. Then we can all sit at home and there won't be look at all the money and the security that's costing because I'm just trying to exercise my First Amendment right as a press,
Okay.
freedom of the press.
Let's hear from the parties.
Can I say something, Your Honor?
No, let's start with the state.
That was Lane.
Your Honor, this court has been
Mhm.
live streaming the proceedings, that it does provide the audio to anybody who wants to listen in. So that's been available. The courtroom is open to the public, so anybody who wants to
True.
see it, they're able to come into the courtroom. 122H only allows personal audio recorders, which is a device used to record audio only. The problem is they're using cell phones. Cell phones are devices that can record much more than just audio. And so they're not the typical audio recording device. If they were holding a handheld recorder, that would be a different device, but that's not what they're coming in with. They have the device that is capable of filming, and that's really hard for court security, court staff to monitor to make sure that there's no recording done of the people in this case. This is a harassment case. Everybody in this case involved, the parties, so it'd be the victim in this case, the court, the attorneys, have all been subjected to being put on YouTube and broadcast. We have the live streaming, so it's open to the public so everybody can hear about it and they can come here in person. There's no reason for them to be able to audio record it
Like what we're doing
separately
right
from that,
now.
and there's no reason at this point to be filming anything that needs to be broadcast. And so to try to maintain the integrity of this case, I think it is important to not have them coming in with their cell phones and video recording it so that it can be broadcast, because that's leading to further harassment in this case.
Okay, Mr. Parvin?
Yes, Your Honor. Real briefly, the reason I want to go first is I understand you have a contested hearing right now. We will be prejudiced if we don't get our hearing as well today, and that's why, for that reason alone, can we handle this another day and just proceed so we get our hearing today? That's the important part, Your Honor, is that you can get the hearing scheduled.
We're here, hold on, we're here on the Mr. Brown's request to film these proceedings.
I'm just saying our position is that you need to get to your other case that was scheduled that's important, so we get our fair hearing at 3. My concern is if we go any longer here, there won't be time for our hearing at 3.
All right. Mr. Brown, I'm going
That's
to
his
deny
attorney.
your request in this case. The courtroom itself is open to the public. Anyone who can follow the rules of decorum can sit and watch everything that happens. We also live stream over our YouTube channel that was made available to us during the pandemic, and which I've continued to use. I'm a big believer in allowing transparency, but there is too much, it's too disruptive in this case by the number of people who've been wanting to come in to record. We can't have staff constantly looking at everyone's cell phone to make sure that they're following the rules. Typically, when we have a reporter who wants to record, they are very reliable of the court orders. And as I said before, there's a certain level of chaos that's happened in this case, and I'm trying to tamp that down. It's hard to follow to make sure everyone's following the rules. So I'm making a finding that use of personal audio recorders would be obtrusive, distracting, and therefore I'm ordering no personal audio recorders in this case. And I'm denying also the request for cameras in the courtroom for the following reason. I'm concerned about the impact on the victims who have been at a lot of these hearings, and whether they would be videotaped sitting in the gallery, which I would not allow. And again, it's hard for us to watch everything all the time. That's the main reason. I just think it's really hard, and it's really affected the proceedings here. And for us to have, we have 6 COs in here to make sure that this is running well. Obviously, we can't do that in every courtroom all the time. So that request is denied. So I'm ordering, consistent with the other case, that the request for audio or video recording or personal audio device is denied. For ordering that no audio or video recording devices or personal audio recorders will be allowed in the courtroom or outside the courtroom within the courthouse for any hearings in this matter. And I will notify court security. So, Mr. Brown, I appreciate your arguments. Obviously, you have the right to file special action with the Court of Appeals if you don't like my ruling, and I think the rule provides for special action jurisdiction. And I don't know if you know how to do a special action or not, but that's filed with the Court of Appeals.
We looked into that, but I just went to federal court.
Okay.
I refiled it.
Okay,
You
that's
should have
great.
got it by now. But the other, can I say one thing?
Sure.
So the other thing is, if you was to do like he was saying, audio broadcast it from audio and video from your thing, all the problems you mentioned would be gone. Every one of them would be gone if you just if you would audio broadcast just like they did at this original hearing.
I am audio broadcasting.
Audio and video broadcast, just like they did at this original hearing in this courthouse when they did this to him. They was doing both. I sat at home and watched that.
Okay.
You know, so
City
I know you
court.
guys got the equipment to do that. So if you would do that, that would alleviate all my problems, and I could sit at home and not have to be here if I could watch it audio and video. So I just ask that you audio and video it, and then I'll be okay with it. And that'll do away with all the problems that you just said. No one will be out
Well, there's
here,
no
you won't have to
video,
have
but
6
there's audio.
COs
There's
in
plenty
here,
of audio.
And then we'll all be happy. So if you could do that for me, I'd be very happy.
Yeah, I'm going to deny that request, but I appreciate you making the argument. With that, we're adjourned and you're excused. We'll take a break and then we'll come back
and
in
we're
this case
done.
at 3 o'clock.
Okay.
So as he's walking away, I don't know if you could hear, but he said, "Okay, lawsuit stands," because he's filed in federal something or other.
Right.
So then you're supposed to stand, of course, when the judge leaves the bench. They actually did for this one because they were hot and bothered. Oh, by the way, as soon as the judge started to give his ruling, I looked over at Mr. Myers.
Sorry. What the hell is this?
That's the outro.
Yeah.
For
I know.
for
I
really
know.
coolness.
I know.
So as the judge was giving his finding on that, his ruling, the chairs that the attorneys and Mr. Myers sit in, they're rocking chairs. They rock back and forth. Well, he was rocking, just rocking. And he grabbed all of his papers. He started shoving them into his folder as the judge is still speaking, tapping it. He was literally tapping out. So again, acting like a toddler. So, then the gentlemen, the 3 amigos, head outside. And of course, all the COs kind of follow. And at first, I was kind of, do I go out there? Yes, I'm going out there because I'm nosy. So now that they are not in the courtroom, you could imagine how they're popping off now. Swearing at the COs. We'll see you in court, getting names and badge numbers again, because apparently they have the memory of a goldfish like me. So the sergeant that had been up in the other gentleman's, face before, she just keeps saying, "Have a good day. Have a good day.
Mm-hmm.
Have a good day. Have a good day." And I'm like, you go. Excuse me. They said, and Parvin made sure that the gentleman with the pink phone knew if any of this stuff gets wrapped up, in this, then he'll have to recuse himself from the appellate work. And I really think I have a good shot at that, at your appeal. Your appeal, I think, has really got merit. So I don't want to mess this up for you. So Parvin was very concerned about that. They were all, it's all the judge's fault. It's all the CO's fault. We're going outside for a smoke break. We'll see you in time for, for the 3:00. Guess who didn't return for the 3:00? There
Mark
was
Brown?
nobody. None of them. None
none of them
returned
attended?
for the 3. None of them
What?
attended the 3.
But isn't that what? Really? So they got so huffy that they couldn't record it themselves, that they decided it's not worth it to them to actually sit in on the hearing.
My
course.
thought was they either didn't want to come back in or they were not allowed back in. I don't know which, because I wasn't going to follow them. Because it's held on the 6th floor of the courthouse, so I'm not taking the elevator for that. So,
Right.
but yeah, no, I mean, for the 3:00, the victim and her family were there, and friends to support her. I did not see Mr. Myers' wife. I did not see anyone for his side. All the people, like I'm starting to get to know the faces now. They were all on the state side, and little old me, furiously scribbling away in my notebook. So
Right.
Lane didn't have anybody there for the 3:00 hearing.
Gotcha.
So I'm glad they stood on their principles.
Of course. Of course they would. All right. So we're going to go right into the hearing. I'm going to skip a little bit ahead into the arguments because this is a 2-hour long hearing. And I have this running at 1.5 speed. But yeah. So the first one is the motion to dismiss on constitutional grounds.
Parvin was
on,
he was so excited for this one. He really had a good feeling on this one.
Yeah.
Requirement was always part of the statute. It wasn't just an intent statute. There was the knowledge requirement that was in existence in the statute back when Brown.
So to try and get you up to speed, Parvin's argument is that the harassment statute was changed. I looked this up before the stream. It was changed in 2002, and it took away language involving where there needs to be, or what he says, there needs to be a specific intent to harass. In other words, it's not enough that Lane Myers makes like 45,000 phone calls and emails and live streams talking about this woman. It's not about that. The state has to prove that Myers did this knowing that it is harassing to the woman, the wife. And Parvin is arguing that that the legislature took away that element away in 2002, and he argues that because of that, that statute is now unconstitutionally vague. And that's the thrust of his argument.
Was decided. And so that's always been a part of this. But what the court has said is that the statute is constitutional. It's talking about what happens across the country doesn't matter again, because we're dealing with what the law is here in Arizona. And the law in Arizona, it's regulating conduct, which may include a blend of speech and conduct, as the case law talked about, but it's still conduct. And what that has said is it's looking at criminal liability based on the manner in which certain communication is conveyed and the underlying purpose for the communication. So the purpose is built into that, of looking at that. And there's also, it has to be directed at a specific person. And then there's also a reasonable person standard. So it's not just, that the victim in this case, whether she's, been harassed by it, but it would also apply the reasonable person standard, which is how they get around and find that this is a constitutional statute. The constitutionality has been upheld. It's already been litigated up high. And what they're talking about with the intent, that wasn't what was discussed in the case law, that the intent wasn't the issue. And with the knowledge requirement, like I said, it was part of the original statute. It's still present. The knowingly requirement is still there. And the knowingly requirement has the showing that he has to be aware that it's doing this. And
is he aware that he understands it's harassing, or only, like, let's give the example where he's calling someone all the time. Does he only have to be aware that he's calling, or that his calling is harassing to somebody?
Yeah.
So I want to be clear, because the court referenced this repeatedly commits an act or acts. That's the first part of harassment. He's actually charged under A1, and that's under the or. So it has to be the person knowingly commits any one of the following acts in a manner that harasses, and it's under 1, which is contacts, or in this case, causes a communication with another person by verbal, electronic, mechanical, telegraphic, telephonic, or written means. So if he is, so it's looking at, is he aware that he is causing the communication with the other with another person. And then you have to also have that harassment under the 132921E. And that's where I said it has to be directed at a specific person. And then there's also that reasonable person standard that has to be reviewed. And so these things are all still in existence with the statute. So the portions of the statute that were discussed in raising whether it was a constitutional statute has already been litigated. And those are still in play in the statute that's in front of us today. And so there's nothing new. And the defense has the burden of proving that the statute is unconstitutional, and they haven't met that burden. It sounds like his argument is, it's being dealt with at the legislature and wanting to talk about what they are or are not intending and what they're doing, but that's not what's in front of us. And so
What if a person is just very unself-aware that their conduct is very offensive to another person? They're not intended to be
That he's so stupid that he can't figure it out, that
communicate
calling somebody 40,000 times could be harassing to somebody?
Would that still be violated of all of the statute?
well, then I think then you would have a problem with the knowingly. Then we would have difficulty proving that
They
because
know
of
that they're calling. They just don't understand that their calling is bothering the other person.
that he's, well, he has to be aware that he's
30.
committing an act that's in a manner that harasses and causing that communication.
Okay, that was my question. Is it just knowledge of calling, or that the calling is seriously
Isn't that
alarming to the other
go
person?
to a
Or
reasonableness?
that some awareness of what he's doing is offensive.
And
to the
during
other
this
person?
Well, he
time,
has to be aware that he's
he has his head down and
committing one of
eyes
the
closed.
the acts in a manner that harasses. So it goes to both portions. He
You
has
know,
to, it's
like
not
a
knowingly just
toddler.
committing an act. It has to be an act in a manner that harasses. And the manner that harasses has to be directed at a specific person, and it has to be, would cause a reasonable person. So that knowingly goes to that portion as well.
Okay. And what about the argument that Mr. Parvin makes that that there's no affirmative defense of legitimate purpose, which I believe there is in the civil harassment statute. So again, what if the person's believing that they're calling an elected official to complain about some public policy matter, and they say, "Well, I didn't intend to harass. I have a right to call."
Well, that goes into that, once again, into that manner that harasses. And then when you look at what the definition of harasses is, that directed at a specific person, and that would cause a reasonable person to be seriously alarmed, annoyed, humiliated, or mentally distressed. And the conduct, in fact, seriously alarms, annoys, humiliates, or mentally distresses. So that's where the fact that it also goes to the reasonable person standard keeps it so you've got both the subjective and the objective standard. So the subjective is directed at the specific victim in this case. So if you just have a victim who's particularly sensitive, that's where the objective standard of the reasonable person would come into play.
And what about the idea that a public official can't block or stop this because the person has the right to call continuously to basically shut down an office? Right? If you have any information, I don't know, you may not be ready to answer that. I don't know if you do or not.
Well, Your Honor, I think every case you're going to have to look at the specific nature. And so, and
In fairness, I feel like that was a little bit of a loaded question by the judge, but
I think that once again, it goes into that manner of harassment. If he was contacting her because of her role as a public official, that'd be one thing. But, and then you get into that's when you start getting into more of a speech thing, when he's contacting because of their role as a public official. That's not the circumstance we have in this case. And you have to look at the specific facts of the case. In this case, he's not contacting the victim because of what her position is when she was an employee at the University of Arizona. He's contacting her because of what the position was of her spouse. And so it's not going to fall under that politically protected speech. If it did, we would be in a different situation. If he was contacting her to say, this position you took publicly, I don't like the position you're taking, as if it was a politician, we'd be in a different place. But we're not talking about a politician, and we're not talking about her role in any kind of public capacity. And under the defense's thing is that basically they could call anybody who works for any government in any position, and just whether it's a janitor. And
Hold on a minute. Mr. Myers, I did hear all your argument. She has the floor now, so I don't want you to interrupt her, okay? I know it's upsetting to you. No, because this is her argument. So just let her talk and don't interrupt her.
so triggered.
So the position the defense is taking is that it could be a janitor who just happens to be working for it, and that they can just call and continually leave vulgar messages and make statements about wanting bad things to happen to them, and then that would be fine. But that's not what the law states. And the law has been clear on any First Amendment issue that the free speech does not protect harassing communications. It doesn't protect that kind of communication. And our statute also does not allow that. And I cited one of the cases in there. It is the Cantwell v. Connecticut case that says, although the statute prohibits certain kinds of communication, it is well established that resort to epithets or personal abuse is not any proper sense communication of information or opinion safeguarded by the Constitution. And its punishment as a criminal act raises no question under that instrument. So this has been litigated on those things with the Supreme Court as far as when we're dealing with freedom of speech in the First Amendment. That's not what we're dealing with here. And we're dealing with the Arizona statute, and the behaviors and the conduct that Mr. Myers was engaging in is not protected. Free speech is not protected under his conduct. And so that is what's being regulated, and that's what we're dealing with today.
Great. Thank you, Mr. Parvin, your rebuttal.
Yes, Your Honor. First of all, I think the state already admitted that we're dealing with one of the sections of the listed ones are A1. Well, now I go back. That's the very language the United States Supreme Court prohibited, a manner that. They said you can't have that. Again, I keep mentioning it because it's very clear in the United States Supreme Court, you cannot have a statute that defines it as a matter that. That's what they didn't like. And that's why the legislature, and I realize the court can't consider that. I only bring it up to show proof that the legislature knows they messed up. That's why they're changing it, and that's why they have to change that phrase from a matter of that to with the intent. Now, the United States Supreme Court won't go as far as that. They're going to say they think recklessness is the minimum. Now, again, I dealt with threats. I'm not sure what they would hold for a lesser thing of harassment. But again, the point's still valid. The knowing only applies on the front end. As the court's mentioning, you're knowingly acting. And I mean, my two examples, I'd like the state to rebut. Tell me why the person in both of my examples is not guilty as charged. That's my concern.
So Mr. Tate's position was not only do you have to know that you're engaging in communication, but that the communication
Engage in my hypothetical, Judge.
Victim into a reasonable person.
Do it.
So you do have to know, you have to have awareness that what you're doing is harassing.
And that's why the statute's vague, Your Honor, because I'm not sure what the jury instructions are here. Are we going to just guess and hope that I want mine? Oh, that's not what it says. I think that's the problem. Is unlike the other statutes where it very clearly says you have an affirmative defense for a legitimate purpose, you very clearly can defend all yourself and saying you have constitutionally protected speech, whether it's social media, in-person picketing, anything is involved. In this one, I'm going to be guessing. I can say what I'd like the law to be, but the state's going to object saying that's not what the statute says. You don't get that jury instruction. That's what makes it vague, Your Honor, is when you read the statute and you're a defendant, and as I mentioned, how are you supposed to know how you're breaking the law? We're discussing this now. It's not clear. Is it knowing? Where's the knowing part? And I mean, that's the real concern, Your Honor, is an ordinary person of ordinary intelligence is not going to know when they are or not breaking the law. And Mr. Myers reviews statutes daily. He makes videos about this, explaining why he's within his rights. He very clearly is negating knowledge here when he tells his viewers how to defend themselves and what he's doing. And that's the problem, is he's relying on the statute that allows legitimate purpose, other definitions. But then here you go with this other definition that is completely different. It doesn't have an affirmative defense. And I keep bringing back my examples because, again, I want to know why that person's not guilty. And if they're not because this assigned prosecutor doesn't want to prosecute that person, that doesn't mean a different prosecutor might want to. And here's another problem. Now you got to depend on your city for politics. Well, maybe you're one of the few in the minority and you disagree with the politics of your city. Now you get a jury of your peers who doesn't like your politics. Oh yeah, you sure harassed that politician, all right, guilty. You knowingly made a video and you told people to contact this person, and then other people did, even though you personally didn't threaten them, you didn't make any bad comments, but other people did, and they watched your video, and we don't like your politics, we like his politics. You definitely harassed him, guilty. You don't get to then argue a defense of, hey, but that wasn't my intent, or that wasn't my purpose. You're still guilty. You're at the mercy of a jury agreeing with your interpretation or your policies, or else they're going to find you guilty under the statute, Your Honor. I mean, they're required to. Because you did make that video, people did watch it, and they contacted this person. Now, you didn't tell them to make threats. You didn't tell them to say bad things, but they did. And now the state wants to put that back on you just for exercising your First Amendment rights. And again, I don't know why we're talking about the facts here. That's not what it's about. The argument today is whether Mr. Myers even has the opportunity to make this argument to a jury. He does not, Your Honor. And if you're saying he does, well, now we're rewriting the statute and trying to guess what the legislature meant. And that's the real problem. Is I would love it. If you want to give me every jury instruction I want here, I'll tell you how to write the statute and what I'd like it to be. I'm fine with that. We'll go to trial on our jury instructions. But the state's going to object, and they'd be right to object, Your Honor. And when we have a problem like this, that's why it's unconstitutional. And that's the whole problem of the statute. And I really want you to review the case I've cited, look at the examples, look at how the United States Supreme Court specifically ruled this phrasing unconstitutional. And I think the court will see the problem here of why this statute is applied, not just to Mr. Myers, but everyone, is unconstitutional, because it's kind of scary. How do you know? Is this person going to, be mad at you and prosecute you because you left a bad review? And look at the Brown. This is what I have a problem with. The state keeps saying that Brown ruled the statute constitutional based on the manner that or conduct. That's not what Brown ruled. In fact, one of the rebuttals, it must have been a very good defense attorney to bring this up, said, we have some concerns. This is unconstitutional because look what happens if you deliver bad news, if you critique a politician or critique a restaurant. It gave several examples of, wow, this could be a problem. You could be found guilty for this. You know what the Court of Appeals said? They said, no, that's not going to happen because the jury has to prove that you specifically intended to harass. They ruled it a non-issue. They declined the defense's rebuttal because they said it's not an issue. And then they even quoted other similar statutes that also require specific intent. And that's all that's needed. I mean, the rest of it may still have problems, but when you can go to a jury and argue, hey, this was not my intent. I had no intent to harass. Here's what I actually wanted to do. I wanted to protect children, as I mentioned in my example, or I wanted to get this law changed and represent the minority. Then, even though you potentially did cause communications and maybe other people harass this person, the jury can find you not guilty because they understand your argument that you protected speech. You did not have intent. That solves the problem. Now, I would like it a little better. I think it needs to have the affirmative defense. But what I'm saying, Your Honor, preferably both, but you need at least one of them. I think a specific intent would cover that affirmative defense based on how the Brown ruled. But I guess I have a real problem with the state trying to say, oh, let's get rid of that part. It's still constitutional. Because you don't know how the Court of Appeals are ruled. Because that statute wasn't before them. Again, this is the first opportunity for a court to rule on the Constitution.
The problem is, I think Parvin might have a case here. The problem is he's trying to pull the cart before the horse. He's trying his best to say, this statute is obviously unconstitutional. It's going to be held unconstitutional. So why bother going through the appellate process to demonstrate that it's going to be overturned? Just say it now, despite the current case law.
It's a very non-attorney viewpoint. What I heard him say in other places too was, you can be the first judge to do this. And
Right.
my understanding is judges do not like to be the first ones to do something. They want to follow
Usually not.
precedent.
Yeah.
Especially not at this level. Like if he were an appellate judge, maybe, but
We have this current
no.
Yeah.
statute, and I have a real problem with the state arguing that we get to just say, oh, use this parts, when that court did not have the full knowledge because they didn't know what this statute was. Does that make sense, Your Honor?
Yes.
Okay, thank you. And Mr. Myers, if you want
Mr.
to
Myers, you don't need to repeat.
No, I just,
Go ahead.
because we keep talking about Brown, right? Well, that was a case in this court. Okay, Brown, State versus Brown was a case in this court, and then it got appealed. So I feel like, I've read Judge Dolly. I read Judge Dolly's and the Court of Appeals, and that's what I'm trying to say here is I feel like they're intentionally obfuscating around, beating around the bush for lack of a better term, because here's exactly what Judge Dolly said. The real question is whether the state has passed a law that has a legitimate purpose that is
Slow down.
that is sufficiently narrow and that doesn't just arbitrarily and over broadly interfere with community. He denied Brown's. Okay, Brown made this argument in the trial court, and this is what Judge Dolly reasoned when he denied the motion. Okay, in trial court before we get to the appeal court thing. The real question is whether the state has passed a law that has a legitimate purpose that is sufficiently narrow and that doesn't just arbitrarily or over broadly interfere with communication and a person's right to speech. The next question is, can I interpret it in a way that it will be constitutional? And the fact that the statute specifically requires an intent that the person is harassing is not sufficient to prove the contact was made or speech was made. The state has to prove the specific intent that the person is harassing in the process. And I think that's what, in my opinion, saves the statute. So that's what he said, right? And then the appeal court picked up on what he said and said, we're going to take it even further and say that the requirement of the intent, and this is quoting the appeal court now. And D, interpreting the statutory language to permit prosecution for constitutionally protected activities would require the state and the courts to expand the statute's reach considerably beyond what the legislator intended. Accordingly, any misuse of the statute, like we're happening here, if such occurs, can be addressed and cured through case-by-case analysis of specific facts. That's why they upheld it. They found that when Judge Dolly reasoned that the only thing that saves the statute, because Judge Dolly would have ruled it unconstitutional and then it would have never went to the appeals court, but he said, can I interpret it in a way that would be constitutional? And I think that the word that the state has to prove intent, his quote word for word, I think that's what, in my opinion, saves the statute. That's gone now. That intent is gone. So if Judge Dolly had this before him, he would say, well, it doesn't say intent. So that literally is his word for word. He asked, can you interpret it in a way that can be constitutional? And he determined only because of the word intent. And then the appeal court upheld his ruling because, yeah, he found that because of the word intent, then we can say, well, he clearly had an intent. Well, we can't do that now. And like you said, you can call public. They're trying to get into the facts. We can't though, but she is a public employee. That's what I don't understand what they're talking about. Of course she's a public employee. And I called her before my wife got fired, not after.
And I'm allowed to do anything I want.
That's the evidence or whatever. But here we're talking about the statute. And the trial court said, the only reason that I'm going to deny Brown's motion in Pima County Superior Court is because it has the word intent. It specifically requires an intent.
Okay. All right. Thank you, Mr. Myers. So we have the motion to dismiss that Mr. Parvin filed in CR 2025-1454, and then that Mr. Myers joined in 2025-1060. So the argument applies to both cases. I believe, first of all, State v. Brown is an appellate case, so it's binding authority on this court, and the standard there says that in order for something to be constitutional and not be unconstitutionally regulating speech, is that criminal liability has to be based on the manner in which a certain communication is conveyed and the underlying purpose of the communication. They then said, the Court of Appeals then said that it's met by specific intent to harass, but it doesn't require specific intent to harass to make it constitutional. That's just what the statute said in that case, and they said that passes the test that they had set forth. In this case, the statute currently talks about knowingly harassing another person and defines harassment. So I'm going to deny the motion to dismiss because I think the knowingly harassing is sufficient to address which type of conduct is unlawful under the statute. Don't interrupt me. Under the statute. So those two motions are denied. Let's go to the next motion.
By the way, he is literally banging his head on the table at this point.
So, okay, Mr. Myers, I've made my ruling. If you don't like it, remember, hold on. If you don't like my ruling, you always have a right of appeal. Okay, so that's just my ruling. Let's go on to the
So
next
mad.
case. Mr. Parvin in CR 2025-1454 has filed two motions with respect to the multiplicitous indictment. One as a stalking count, and then as I think of the other one as to the other count. So, Mr. Parvin, why don't you argue those next?
Yeah, so, Your Honor,
Unless you don't want to do those today, or
we're going to do them. It's just my concern is I want Mr. Myers to just get the same problem in the other motion about so many different charges for the same thing. It applies to his case too. That's my only concern.
So this motion is, I think he's Parvin's trying to either eliminate at least some of the charges, as they say multiplicitous, but they're duplicitous. I like the duplicitous sounds a lot easier to me. They say that the charges in the second case are effectively the same, involve the same conduct as the first case, and therefore, they're basically charging him 2 times for the same conduct. That's Parvin's argument. The state's gonna try and argue that the there has been a sufficient separation or pause such that to warrant the second count, the second charge.
And
You want me to find that he's joined in those motions?
yes, at least
Okay.
only one. Yeah.
You don't have any objection to that, do you?
No.
All right, so I'll find that the motions that Mr. Parvin's filed, one is motion to dismiss count 6, stalking already multiplicious as to charge offenses in the earlier case, and the motion to dismiss the multiplicious harassment counts also apply to CR 20251060. Mr. Meyer joins in these two motions without objection. Okay, go ahead, Mr. Parvin.
Well, in this case, it's one series of conduct for everything. As I think the court has heard, that this is a question of whether this is legal or not to protect his speech. It's not fair for the state in this particular case, it's one course of conduct, to charge it 20 different times or whatever they did just to try to prejudice a jury into getting more convictions or saying it's a bigger issue than it was. Obviously, and again, I'm not sure what we're going to do for jury instructions now. It's going to be a problem because of this we were talked about, but I don't
he's still butthurt over the ruling.
Charge that 20 times, and even indictment. I'm trying to figure out which one applies to. Is it which days? It says back to back. It's really one act, and the state is trying to go fishing here and try to do this over and over and over again. When really it's only one course of harassment, Your Honor. It's one course of stalking, and at least the reason I brought it up is in the first case they charge a bunch of harassments, only one stalking. They acknowledge it's one course of conduct, and some of them got a couple months apart. Yet somehow, all of a sudden, only like 13 or 14 days, whatever, I think it was 19 days that he stopped. So they're saying he didn't stop, even though there's a break. But that's one course of conduct. But yet somehow he stopped and started again 19 days later. The
So
state, that's my
Mr.
problem.
Parvin, let me ask this. So the state charges several acts of harassment. They got an indictment. Then after the indictment was returned, they allege new acts happened. So how are you saying that he has immunity as to those new acts because they happened after the indictment?
No, again, my motion, they're separate because that's why it's tough because in that case, I'm only talking about the two.
Found
arrests.
as
They're
good
back-to-back
judge.
videos. So what this was, the state alleges, and we disagree it's harassment as the court.
Are you saying that they're multiplicious as to respect to the first indictment or only as to themselves? There only should be one count in the second indictment.
In my motion, I was talking only about the two at issue in the case number I'm still the assigned attorney on.
Are you saying that those two charges should just be one count?
Correct, because
Okay.
there was two videos made at the same time, back to back. That's what it should be one count.
Okay.
It was not two separate acts. No, I'm talking about the harassment, only the two
I
in this
see.
video.
Uh-huh.
That's what's both. I filed that one. I don't know if you saw that one. Same argument. State magically thinks that even though they said, a couple months in advance, it's one course of conduct, that all of a sudden he stopped for 13 or 19 days and then started again. That makes zero sense, Your Honor. That is the same course of conduct. There shouldn't be two separate stalking counts there. And that's why the definition of stalking is a course of conduct. You need more than one act. And that's the other problem, is that as far as the two harassments back to back on this case number, you need more than one act. So I would agree the state could charge it as harassment, but for the two together,
Yeah,
it's
so
not
that-
just the one. So that's why it's
So
So that's what Parvin's argument. Parvin's argument is that because stalking and harassment generally involve a series of multiple instances of conduct that rises to the level of harassment. Parvin's arguing that these second charges are effectively just simply an extension of the conduct that is the basis for the first charges, and therefore the state is double dipping in trying to charge him twice for the same group or the same set of conduct for harassment and stalking. That's what he's arguing.
again, remind me, in your case, there's one stalking count, right?
there's one stalking, but I'm arguing it was an unnecessary indictment because it's already covered from the current ongoing alleged stalking.
Right, but it's acts that happened after the indictment of the first case. So how did the state address that?
It's not acts that happened. It's ongoing conduct that hasn't stopped.
Would it
The
would it
state
be
would amend what the state would do is, again, we just disputed stalking. We dispute that. We're not saying it's not. In fact,
Right.
So what the judge is saying is like, well, the conduct alleged in the second case is all conduct that occurred after the indictment on the first case. So what the judge is trying to say is like, I don't think the state is going to be including this additional conduct as part of their case. They're only relying on the conduct leading up to the indictment. And if he continues to keep on doing that, does that not allow the state to charge him for charge him again for new conduct that occurred after the indictment?
I forgot to bring it up later. We'd like an extension on any rematch for grand juries. We're still looking at that because these motions, so many motions here. That'd be part of that argument. But the point is that this is one course of conduct that hasn't stopped, which is why the state should then be amended. If they want to include up to today, they should amend the first stalking, and we'd have no objection to that, to include ongoing conduct. Because either it's illegal or it's not. It hasn't stopped. So that's the problem. Whereas the state wants to say, no, he acknowledged this was wrong and stopped doing it, and then he felt like doing it again a second time. That's what they want to tell the jury. Well, that's not true. He's acknowledging he's doing it because he doesn't believe it's illegal. That's one course of conduct. It's not two separate criminal acts.
okay? And then as to the two counts of harassment in the new indictment, Are you saying that those should be one count, or that they should just be covered by the first indictment?
That one was sufficient pause. I would say this would be one separate additional count for these two.
Mhm.
But we're not. I understand the slightly different
Lane
arguments. The
was
stalking, I'm saying,
so
there was no new conduct. It's the
mad.
same course of conduct.
Right.
For harassment, this was an additional act, alleged additional act, but it
As
was the same
Parvin
additional act
is
to work through.
arguing this,
Okay, if that makes sense. Your
Yeah.
Honor.
Lane is shooting him
All right.
death
Mr. Ellis, your
glares.
response?
Who, the
Your Honor, I
judge
cited
or
State v.
Parvin?
Rios, and
Parvin.
that case is important because it
Ah.
talks about
So-
when you have a victim-directed activity. In that case, it dealt with someone who was sending multiple text messages to a victim, and the court found that each text message, even though it was in a one-day period, each text message was a separate. It could be a separate harassment count.
That's the Rios case?
Yes.
Uh-huh.
And so this is victim directed. These are separate acts. So in talking about the two new videos, they're on separate days and they're completely separate videos. So they're separate acts from each other that are being directed to cause this communication with the victim in this case. And so they can be charged as separate acts.
What about the
So,
argument that the statute requires multiple acts?
so we just talked about that again. It doesn't require multiple acts. What I talked about is there's the first part of the statute, which a person commits harassment if the person knowingly and repeatedly commits an act or acts. That's one portion. And then it has the person knowingly commits any one of the following acts in a manner that harasses, which again is talked about in Rios. And that's the A1, the contacts or causes a communication with another person. And it gives the different means you can do so.
Okay.
And that's the or is a separate thing. And that's reflected if you look at prior versions of the statute where those have always been separated out. So for this one, it doesn't require that repeated. So that act, that's when he's knowingly committing an act that's in a manner that harasses, causing a communication, that's its own separate act. And so we can charge those as separate ones.
And as to the stalking, why not just add that, amend the indictment of the first case to add the additional acts?
So, Your Honor, the stalking it's another broken up one because there has been an intervening thing. The time frame did stop, and then there was this intervening act where he was indicted on charges, and then after he was then given release conditions, he started again. So we do have that
He
intervening
started
act.
again.
So they
Yeah.
are separate. So just because we could do this really broad range doesn't mean we have to, and nothing requires that. And we do have that separate time, and we have a big separate act that happens in between there, this intervening event before the new time frame starts. And for the stalking, we have to have at least the two different incidents, which we have in this case, which is why there's also this additional stalking count.
Okay. Mr. Parvin, your response, if you could address that Rios case or your rebuttal, I should say.
Yes, the state's right about Rios. The problem is that I wouldn't say they're misleading the court. They're just making an argument. Rios dealt with actual separate incidents where the person's aware, yes, I did it, I stopped and did it again. And that's every trial, there's a start and an end point. So it's different than when they say, because there's an actual victim, that needs to be individually charged. What makes Rios distinguishable is in our case, there was no stopping. As in, this was, and the statute says it requires a series of conduct, multiple acts. So especially the stalking, is the state really arguing that he stopped and then started to his detriment? If he stopped and then certainly he's not going to start again after potential release conditions. No, he kept doing it the whole time. He kept making videos because he believes allowed to, and this is not stalking. So this is one course of conduct. Now, that's for a jury to determine whether Mr. Myers is correct or not. The problem is with doing this twice, the state is going to tell the jury, oh, he acknowledged it, he stopped, and then he started again and did a separate crime. That's how they want to tell the story to a jury, that this was two separate crimes. It's not, even if the jury thinks it is a crime in the end. And furthermore, there was no, this one only had one act. If it requires a series of conduct, they're going to say stalking again. There's not a course of conduct again if you're going to start it over. If the state wants to start over, they don't have that series of conduct again. Same problem with harassment. And again, I think that's why I'm conceding that this does not apply to the first one for my harassment motion, because that was a separate act in that case. And I'm not conceding it's harassment. We don't think it was, but there very clearly was a stalking point in the
He's
sense
trying
that,
so hard
there was
to
a couple breaks. He didn't make any videos, but he maybe upset over it, but then he did another
like
act.
walk
There was a
that
clear
fine
defining point
line.
where a separate act started again that could be considered another harassment, although again, that's a problem as we've already discussed. But for this, for the two at issue, these are back-to-back videos. It's the same exact act, making two videos about how upset Mr. Myers was and that he's wrongfully charged and he had his legitimate purpose. We'd get to that at trial if the court permits, which is a problem, as I mentioned. But that is only one charge, Your Honor, not two. They didn't stop and end the next day. It was one harassment. Same with the stalking. Same course of conduct. Please read the statute here. There was no stopping point. And that's the other side of the difference, Your Honor. We're not saying he stopped and started again. We're saying he never stopped. And honestly, he'd probably still be doing it because he thinks he's allowed to. And he may be right. Mr. Myers may be right. But he's now respecting the fact that the state has, saying don't what's going on. He stopped, but not because he wants to, because he believes in the right to do so, Your Honor. If that makes sense.
Okay. Mr. Myers, what do you want to tell me?
About the stalking. I didn't make a video about Shannon Walker between October 21st and January 22nd. Why didn't I get 2 counts of stalking right there? That's months in between, not even 19 days. If they're going to say it started and stopped, well, it stopped October 21st. And then
Charge me more.
That's a lot more than 19 days.
Please.
So they could have hit me with a new 2 stalking counts right there too, but they didn't. They could have actually hit me with a new stalking count because I didn't contact her from September 12th to October 15th. That should be 2 stalkings. October 21st to
Oh, I don't think Lane understands prosecutorial discretion, but
No,
Okay.
not at all.
January 22nd. That should be another count of stalking. January 22nd to February 22nd, new count of stalking. So I mean, how can 4 months go in between and it's 1 count, but 19 days and it's not 1 count?
We just want a
All
fair
right.
trial, Your Honor, on the actual alleged act.
All right. I am going to deny the motion to dismiss the stalking count and the multiplicitous harassment counts. I do find on the Rios case that each act of harassment can be charged
Denied.
as a separate crime. And with respect to the stalking counts, there was an intervening event of the indictment. And I don't think the state is required to just amend the indictment. They can charge it as a new stalking count. So that addresses those two motions. Let's next go to, I want to do the bail thing.
And
last.
again,
Let's talk
Lane
about
is
the
thumping his head
legal
down on the
resources.
table.
I'm trying, I have the state's response.
Can you start a hearing for that?
Oh, hold on. I want to,
It's a notice, not a hearing or a motion.
all right.
I don't feel it's fair without bringing the people involved in and having put them under oath.
Did the defense file a motion respecting legal resources or just raise the issue?
No, the state did.
Your Honor, it's the defense raised it in the motion regarding the bail eligibility.
Right.
They raised the issue, so I made sure to provide the court the notice and the defense notice of what
Okay.
has been provided.
Mr. Parvin, you want to argue?
Can we
that part of
talk about the legal
bail, or-
resources
I want to
already?
address, because I'm
Sure.
So he said long ago that he didn't have access to law library. He had to have a special motion or special order from the judge. Miss Stiles contacted the jail, which, apparently Mr. Parvin could have, but okay. And they said, we do not have a physical law library anymore. What we do is we have LexisNexis on all the tablets that the inmates use.
Right.
Now, Lane likes to say that there is one tablet per 25 prisoners. From what Miss Stiles says, there is one tablet for every 2. So Mr. Myers wanted, I need at least like 3 to 5 hours a day or something like that, so he can do his studying up on everything. From everything that the state is saying, because Miss Stiles is talking to every, up and down the line in the in Pima County Jail. How does this work? Who can have access? How long is it charged for? How often is it passed around? That kind of thing. He should have plenty of access to LexisNexis and everything else that he needs for his case on the tablet. Where he's coming up with one tablet for every 25 prisoner, who knows? The fact that it's used, it is the same kind of tablet that is used to connect to family, friends, whatever. And the only question that Ms. Stiles has been trying to chase down is because most of her evidence is Mr. Myers' own live streams. How to get that, she had a stack of CDs burned with all the videos that she plans on using in the trial. How to get those in usable form to Mr. Myers. And what it turns out is that they figured out, since Mr. Parvin is, at least he's on one of the cases, and advisory on the other, that if Mr. Parvin can utilize the media in that form, then he can make sure that Mr. Myers has access to it in his visits to the Pima County Jail. I will say, Pima County Jail is way out there. It is not a fun place to get to. But you gotta do what you gotta do. So all of his popping off about having access to the law library, from everything that Ms. Stiles has been able to figure out, he has fine access, all that he wants and needs. But he's going to keep bringing it up.
I want to make sure that he does have access to legal resources. So
I want to hear it.
go ahead, Mr. Parvin.
I'd like to pause. I'd like to get ready for the main hearing, which is the bail hearing today. Why I believe we're entitled to bail or rehearing, because this could be a moot point after. I don't know, but that's really the heart of it. Is why I believe Mr. Myers should get released on conditions, and
Okay.
I'd like to prepare for that because this may or may not be a moot point after that, and I'll be addressing some of that in that.
Okay,
hearing.
so let's go to, in the new case, CR 2025-1454, motion for rehearing on bail pursuant to 7.4C. And Mr. Myers, this only does apply to the new case because you do have bail in the older case. So we're just going to hear from Mr. Parvin.
Skipping this notice regarding and stuff.
But we're going to address it as part of this. But I'm just going to hear from Mr. Parvin in part because it's only the second case and just to conserve time. Okay, so go ahead, Mr. Parvin.
So I think the first hurdle here is I need to prove this court why we're entitled to a rehearing. And I think I laid that out in my reply, as well as the introduction of my original motion, is that this is a separate court than the consolidated court. What I mean by that is we disagreed with the new charges. We disagreed how it happened, but we had to act quickly. I was up almost all night trying to prepare an argument on short notice for that bond hearing. We got it done. But that was in a limited jurisdiction court before the indictment under a separate case number. I think it was, I can't remember exactly, I did an FE for felony. It was in the Pima Consolidated Court. yes, this court was used to facilitate a hearing, but it wasn't under a Superior Court case number. It was still, everything was filed in the Pima County Consolidated Courts. Thereafter, there was an indictment, and then if you look at the file, it was all transferred to the Superior Court for arraignment. That is why I think the rule very clearly says when you get transferred to a new court, then you get a rehearing. Now, I'm not asking this court to do a full evidentiary hearing, but
Why not?
hold on, Mr. Myers, because a lot of that was already litigated. The court can use a lot of those facts. Now, there may be new stuff where testimony might only happen at any rehearing, but so I'm not saying we get a complete do-over on everything that's heard. That'd be a waste of time because we're not disputing that. But Mr. Myers is entitled to a rehearing now that we're in a different court to address the same arguments. And the reason that got me thinking is I know that this court is actually the appellate court over the Justice Court. So I thought about what are our options if we disagree on short notice? We could special action, but we don't have to. And that's why I think the rule is created that way. It acknowledges you've got a couple days to prepare for that hearing. You don't have a lot of time. So that's why once you are transferred to the Superior Court, the rules allow you, rather than special actioning, to then apply for a rehearing with the assigned judge, address the arguments again when you've had more time to prepare, when you know more of the facts. And I'm not saying this court needs to act in appellate capacity, because you don't this time. But because you don't need, I mean, you could, but the court is free to make its own findings of facts. And I want to say, here are my concerns. I'll respect that court's ruling, but we were on short notice. I don't think Mr. Myers got a fair hearing on the finding of fact on whether he was on pretrial release. I made a very clear argument why we thought that it was so heated, it wasn't official till Monday, and nothing happened till Monday. And yes, that judge, though I disagree, found that an alleged felony might have happened, but didn't really rule, if you listen to the audio, on whether our argument was correct when it became official.
Let me ask
The
this.
real findings of fact on that.
What was the issue on the bond hearing, the fact that he was on release when he was charged? I mean, you don't look at the, and he was indicted, right, on the new counts, or just
It
charged?
doesn't matter if you're indicted. You have to be actually on pretrial release when that becomes official. So the argument was that similar to how this proceeding, before we can special action or appeal, we can't do that until there's a final order from this court that's official. Even though you've already ruled, it's not official until that minute entry comes out with a final judgment saying, here's my ruling, and now we're free to go to the Court of Appeal if you need to. It's similar here, is that the argument I made, and I still think it's a valid argument, is that it was so heated, there wasn't time to process, the minute entry did not go out, it was not official until Monday morning when all of a sudden, hey, here it is, here's the minute entry, we got to deal with this. And again, that judge, and I respect the decision, she took her time, she reviewed evidence, she did go back and spent quite a bit of time reviewing the evidence, so she did a thorough job there, but she missed this point and did not really make any findings of fact on that argument. And you listen to the record, nothing was mentioned about it, of when it became official. And I know this court has done civil before, similar to that, is you need a final judgment before it's an official order appealable. It's the same thing, is there's a reason it gives you that break. On that example, when you're convicted of domestic violence and you lose your gun rights, they don't just say you're guilty now for running a gun. I think they give you at least 24 hours. They say, no questions asked, you have time to process it, it's not official till tomorrow, do what you need to do. It's no different here, is there has to be a cooling off, unwinding, processing. You have to see in writing in that minute entry that these are the terms, it's official. Because the law gives you that. You need time to process. You heard how Mr. Myers is upset. Anybody, I'm not saying the court was incorrect necessarily at this point, but yet I'm saying you need time to process that. That's what it gives you. You're upset about the hearing. Things are going to happen, and then the minute entry comes in, you read it, you got to deal with it, and then it's official. And
So let me ask, in the original, he was indicted, was he summoned on the indictment? That was the first thing, right?
Correct, but it's not, again, the way the law defines pretrial release, it's when it's official.
So he appeared for arraignment. He voluntarily showed up, right, on the summons?
Yes.
And then the judge holding the arraignment released him on conditions of pretrial services, right? At the hearing?
It was heated. There were a lot of things said. I don't know that they're necessarily understood because of how there were security here. There were people that didn't like Mr. Myers. They had to protect Mr. Myers from these people. I don't think it was necessarily official with the terms until the minute you came in, you could see it in writing. That was the issue.
And typically, when you have, at least in this court, when you have release conditions, there's a form that's filled out and given to the defendant at the hearing. Did that not happen?
Yeah, that would have
Took
been.
me out, so that they made me go out first, so then the victim could come after me. And that was like counsel, so I'm assuming it would have went to him.
So are you saying, Mr. Parvin, that he didn't get a copy of the release conditions?
Saying is that part may not have been addressed. I know I immediately talked about Monday morning about this, and it stopped. That was our whole argument. Is the conduct did stop right away Monday, and we said, "Hey, what you doing? There's a minute entry here." I think that may have been a disputed fact, and again, that wasn't addressed last time. Mr. Myers didn't testify.
I want to hear him.
But
Okay,
again, that would have been, again, I thought, but I want to make argument today is the first proof that we get a rehearing. I just hope the court would agree that based on the rules that we are entitled to a rehearing of the transfer of courts, because I have other arguments to make as well. That's just one of the arguments.
Okay, I'm just kind of trying to figure out. I understand you're asking you're entitled to a hearing.
Yeah, I'm saying, yeah, we could get an evidentiary hearing at the court. It's either or, and Mr. Myers would like one, but I don't. What I'm saying is,
testify.
Don't just let Mr. Parvin talk. You can't.
I'm
talk
just
over
saying,
him.
I'm not requiring the court to call the same testimony that's
Oh,
in the record.
Lane hated that.
Right.
Mm.
Lane was he's shackled at the waist,
I just want to see.
and he kept trying to raise his hand. Like, I mean, I gotta talk. He was bouncing.
I just want to clarify that we could get that.
Yeah, I'll talk about that. But appearance order with release conditions is a form that, let's see, it was dated March 14th, which I assume was the date of the arraignment. So okay, well, because I think that goes back, Mr. Parvin, to under the rule 7.4C, if a motion alleges the existence of material facts not previously presented to the court, or the defendant is unable to, well, it's not previously presented to the court, what your argument is to get a new hearing, you have to show that there are material facts that were not previously presented.
No, no,
Oh, it's
the
an or. Oh, no, let me talk. It's actually, as I mentioned, it's an or. As in, we disagreed with that judge's decision, so we could special action. But I read the rules. We don't need to. We're alleging new facts, and we'll get into that. But I'm saying just before we even get to the new facts, it's a two-part statute. It says if you transfer courts, you automatically get the hearing, even to get a different opinion from the newly assigned judge to make new findings of facts. Or if let's say this court rules today and doesn't agree with us. Well, if we present additional facts, then and even in the same court, we can request a hearing again with those additional facts. It's an or. So when you transfer courts, you get a rehearing just because you transfer courts.
But it says, hold on, it says, if the case is transferred to a different court, if the motion alleges the existence of material facts not previously presented.
Come on.
So typically, Mr. Parvin, as you know, we hear these all the time, and the argument is the defendant has a place to live, or the bond's excessive, or he wants to go to drug court, or some type of drug treatment. There's usually some allegation that a new fact has arisen.
The case law says it.
Mr. Myers, I just want to hear from Mr. Parvin, okay?
Yeah, because this is unusual. That's when there actually is a bail and release conditions already about a question of what they should be. In this case, we're disputing whether Mr. Myers was bail eligible to begin with. We think he should have been. So that's why we're taking advantage of the first part of the rule that we would get a rehearing similar to an appeal, although not really because this court is not in appellate capacity, just a different court.
It's a rehearing.
A rehearing, and that's why I'm making the same arguments that I don't think were fully addressed by the prior tribunal on when the release conditions became official. And again, Mr. Myers now tells me that he didn't get that pay. I didn't know, there was, again, we had to work so fast, but that will be an additional fact alleged that he'd like to testify about as of whether he actually received that paper that day or not. I can tell the court, I immediately, before he talked about Monday morning about it, I got the insurance and said, this is official. That I can tell the court that we did have a conversation on that Monday. It might not have been Monday morning, but it was not Monday about it. But as far as Friday night, Friday, it was heated, and we kind of, or at least I did, took a break from the case for a couple of days in that sense, if that makes sense, Your Honor. And then the order came
Okay, so
Monday.
did
But again, I
did
have
everyone
argued
catch
this
that?
One of the
The minute order came down, what was written on a Friday, it was so heated that Parvin needed to take a couple days away.
Huh.
And that then shouldn't there be a cooling off period, Your Honor? Shouldn't there be in a harassment case? Are you kidding me? No. But yes, Parvin needed a couple days away from Mr. Myers. Okay.
Naturally.
Hearing. You want a hearing, right?
Right.
Yeah.
That's why we just want a hearing on the issue.
All right. Mr. Osmond, we typically grant a new hearing on reviewing of conditions. I mean, we do it all the time.
Not in these cases, Your Honor.
So what's the difference between a judge at the beginning of the process setting bail as $10,000, and then they come up and say, well, he's got a place to live, he can live with his mom, blah, blah, blah. Please reduce that to $500, whatever. How's that different than this?
Because then you're talking about offenses that are eligible for bail as a matter of right. This one is not. This one, based on the Constitution in Arizona, is not eligible for bail. And that's been built into the rule. So you have the Constitution, which is the Article 2, Section 22, that says it's not eligible for bail. And then you have the rule that also...
And it's not eligible because he was on release and then committed a new offense. And
Allegedly.
Yeah, allegedly. But when...
Allegedly.
I think it was Judge Miller did
Allegedly.
the bond hearing, correct?
Correct.
When she heard that, was the question only, was he charged in a new offense, or you have to put on evidence that he committed the new offense?
So, Your Honor, we did everything in the case. So when the state alleges that somebody has committed a new felony while on felony release and is seeking to hold them without bond, the state is required to put on the evidence and have the hearing to show that proof evident presumption great that they committed a new felony offense while on felony release. And that happened in this case. So the documents that the judge was...
So the detective testified at that hearing.
Correct.
And did kind of a summary like you do before grand jury.
Yeah, so the detective came in and testified, and we had the exhibits. So in this case, it were videos, and so those were presented to the court. The defense had the opportunity to cross-examine the detective, and that occurred. Mr. Myers had the opportunity to testify if he wanted to, and so he was advised that he had the right to testify if he wanted to, and he chose not to. And that was all done. And then we had certified copies to show that Mr. Myers was on felony release at the time. And so those were also considered by the court. And as the court just noted, it was the March 14th date. So Mr. Myers was present for his arraignment when the release conditions were set. They were done both orally, where the court advised him of his release conditions. And that was a pretty lengthy process of the court addressing that. And then he also had it was all ordered as well in the documents. So that all took place as well as the testimony. And the court, on the no bond hearing, after hearing all of the evidence, made the determination that the state met the standard of proof evident presumption great and found that he was on felony release at the time. And so he was held without bond. So the defense is arguing that he's entitled to this reexamination, but that's not what the rule says. It says may. But what that rule also says is that under it talks about that the court must hold him when that standard is met. And so he is not entitled to just keep coming back because he doesn't like what the judge previously determined. There's nothing that would warrant this case revisiting that issue when the hearing has already been held on that. It's not like he waived it before or something. We actually had the full hearing on it.
Okay.
May I respond?
Yeah, hold on just a minute. Before I do that, I want to pull up the indictment on the new case, just so I have the dates clear in my mind. Hold on just a minute.
During the state's rebuttal of Parvin, Parvin is trying to listen so that he'll know how to respond. Mr.
Right,
Myers
So,
is
Mr. Parvin,
pestering
again,
him.
The arraignment
Didn't go well.
on the new case was,
April 4th.
That was the new case, yeah.
March 14th.
Well, that was the first one was March 14th.
The new one was April 4th.
Oh, I'm sorry. Yeah, right. All right. So in the first case, the arraignment was on March 14th, and there is a order in the file of the judge who signed that release conditions. He's on pretrial release. You're saying that order and that hearing wasn't. I don't know really what your argument is, because there is a court order in the file of
Yes,
that date.
But the minute entry with the stamp with the clerk was
Yeah.
not
Well, this has
official
a sta-
until
I mean,
Monday the 17th.
I just don't. This is also stamped the 14th by the clerk.
We had it at the hearing, though. That was.
Hold on. Let's hear Mr. Parvin. Hold on. So, Mr. Parvin, just mechanically, the way it works is, arraignment was held on the 14th, release conditions were set in open court, and the judge signed an order which was filed on the 14th.
But it wasn't. Well, there was
The
something.
minute entry is only recording what the judge said. This is an actual order that's actually in the file.
And I guess the question was, Mr. Myers, I get was paper saying, I don't know if I might have been aware of it, was not aware. So when the minute entry came and acknowledging it, that was the argument that was not properly, at least, when the law was attempted to be addressed, but I don't think it was properly addressed on the question of, was there proof evidence of that, Mr. Myers' knowledge of it. There's also a constitutional
Hold on.
issue.
But let me just. He was advised of that during the hearing. I mean, you haven't provided me with the transcript, but I'm just assuming, and I think, Ms. Stiles, you were present at that arraignment.
Yes.
It seems to me that the judge in that case did address that he's on release. He was given a release as to the indictment, and there's an order. So, I mean, he was on notice of this. I mean, it was told him in open court.
Again, the argument is a cooling off period. Like, for example, I brought up the domestic violence. Technically, if you're convicted, even of a misdemeanor, the judge says you now have lost your gun rights. I find you guilty. You need to turn your guns or you'll be a prohibited possessor. But there is, like, I think it's 24 hours, a period before it becomes official to give you time to process. And that's why I bring up the 17th. By then, it was official, and the conduct stopped. That's the same. Once we had a conversation on Monday, after I guess it ran late on Friday. I was tired. Mr. Myers, I'm sure, was tired. Well, I was even more tired, I think, because I didn't want to this case till Monday, nor should I have, because nothing should have needed to be done that time. But then I immediately talked to Mr. Myers. I don't know when on Monday, but it happened on Monday, and discussed this minute entry that came in, and then I found out some stuff was happening.
So, for example, this order says, do not go to the victim's residence. And let's just assume, for sake of argument, so this was Friday the 14th. Let's assume, just for sake of argument, I'm not saying this happened, that Mr. Myers then contacted the victim on Saturday morning. Are you saying that wouldn't be a new offense while he's on release and be held without bond? I just don't. I mean, to me,
Sounds like a bullshit.
Well,
he's
Yeah.
for trial, and he's out in the community, but with the restriction that he can't commit any new offenses. And he commits a new offense just driving home that night. Let's say it was a DUI case.
Yeah, I'd be out on bond if I got a DUI.
Well, not necessarily in that case.
If I could assault somebody, I could be out
Let me
on bond.
explain that. So, yes, I mean, in the sense that if there were a direct crime there, it's obvious. The problem here is Mr. Myers, and again, I'm going back to constitutional arguments of what the trial would be, legitimately believed he had a right to defend himself and talk about that he didn't believe the charge unfair. He didn't believe he's committing any felonies. And he strongly believes that. And that's going to be a problem for this jury about defining the statute, as we've already discussed. But it wasn't going out there and committing a DUI or contacting the victim directly, something obvious. And then what happened was the release conditions were a little tricky to understand. There was a lot of debate. It was very heated on Friday. I'm trying to see exactly what you're getting. Remember, you get a piece of paper. We knew not to contact the victim directly. But there was discussion. I know you didn't. There was some question about what was and was not
They
permitted.
charged me because they said I violated the injunction.
Hold
It's
on,
not a
I'm trying
felony.
to explain. So
Mr. Myers, don't talk.
the problem was the cooling off period ended on Monday. It was a weekend. Now, in your example, if the next business day, if this were Thursday, then Friday would have been discussed. The minute you've been in, and then have been official. So the only reason there was a couple days is it was a weekend, and on Monday is when this was addressed. And as I made in the argument before, the conduct stopped, which means that proves Mr. Myers was aware this was official and stopped doing what he was doing at that point.
Let me ask this, Mr. Parvin. So the standard release conditions on his March 14th order says violate no federal, state, or local law. So that's in that's in the statement of conditions of release. The minute entry would not have said that itself. The minute entry only says he's granted release with these conditions. It doesn't go through the standard condition. He's alleged that he violated a standard condition. He violated no state law.
Okay, and I still think the better argument was it was official Monday, or at least a good argument. Now I'm starting to think the better was the other way around. Is we'd also like to address, because it did transfer courts. I want to again say there's a comma. There are three. It's not one sentence. It's three specific scenarios. We also would like a chance to argue at a rehearing of why there was not proof evident of these last two felonies. It's not just about it. I mean, I thought.
So I'm not doing well with this one. Let me change
horses. Situation on
horses.
short notice, the best argument to focus more on was that a pre-trial release was not official. Now that I've looked into the evidence more, I'm realizing, the better argument is that no felony even occurred. And he's entitled to rehearing that as well. As the court acknowledges, people make that request all the time. Why is this any different? I also made a constitutional argument, if you look at my reply, is yes, the Supreme Court, they can't really indicate written or whatever, there was a Supreme Court decision saying that upholding the denial of bail, saying it wasn't unconstitutional statute on the whole. But what it didn't say, it was that each individual couldn't come in and make a constitutional challenge. So that's why I want a hearing as well. And I bring up the problems at the jail where he's deprived of the law library, they're monitoring it. This is a very unique situation. Mr. Myers needs people to help because advice on challenging the statute is different than any other crime. Hold on, Mr. Myers, I'm getting there. There's a lot of arguments I raised in addition to this first one. I just want to address all arguments. The other thing that I'd like to address at the rehearing is the facts now is And I'm going to talk to Mr. Myers about it. This court is a lower court. The court feels it's bound by the Brown despite the change in statutes. And I understand the court's side as a reasoning believes that's still binding law, and it's our duty to then go to them and get the Court of Appeals changes. But I hope the court at least, and I think the court does, because you're asking questions of everyone, understands the dilemma here. Part of the argument I'm going to make for bail here is this situation is much better decided before trial on a special action rather than hashing this out on what is going to be the messiest of trials. And we have no, again, I'm going to request jury instructions. The state's going to object. I have no idea what the court's going to allow or not at that point. If the court grants release conditions, and it can be extremely stringent, and I'm going to make the constitutional argument, what we can do then, we can postpone this trial, and we can then out of custody, so Mr. Myers is not prejudiced, special action, the court's decision, and let's see what the Court of Appeals thinks. They can revisit their own decision on this new statute. That's fair. Well, I'll tell you what would not be fair, Your Honor, is for the court to say we have to go to trial under this, what we believe to be unconstitutional, and it may be. We don't know how the next court's going to rule. And now he sits in prison or sits in jail while it takes me 60, 90, maybe 120 days to get an appeal done. I'm going to get help. There's already organizations contacting me. They want to be part of this appeal based on the First Amendment issue. And I need time. I need a couple months, a few months even. This is going to be it's going to be an epic published appeal, Your Honor. I think the court believes that to be the case as well. And Mr. Myers should not be in jail or in prison right now, battling out whether this statute's unconstitutional. And I'll be making that argument after a hearing, but I'm just saying all the reasons why I'm going to bring up that there is a second part of what the court believes is fairness, a constitutional grounds of granting bail based on facts. And that's what we're saying now. If the court,
Let me hold on. So Judge Miller looked at the evidence that the state had presented as to the new charges. And what I don't hear you saying is that that's going to change. So it would, hold on, it would just me being the second guessing Judge Miller, which to me doesn't, I don't think what the statutes or the rules directed at.
It says you can have a new evidentiary hearing.
Hold on. New facts, something that wasn't already considered. You see what I mean? I don't want to check her work basically, because I'm not an appellate judge.
it's and I understand.
Because judges don't like doing that, right, Artie?
No, I want to hear from Mr. Parvin.
Why can't I speak?
Because it's his motion that's as to the new case. And I want to hear from him. This is a very technical point.
I know, and it's just talking in circles. It says you
No,
have. It says if it's transferred to a new
Myers,
court,
have
you
a
can get a hearing,
conversation.
and the court can order a new evidentiary hearing and you can find proof evident or not. It's clear.
I'm
It's
reading
black
the
and
rule-
white.
I'm reading the rule different than you are. Go ahead, Mr. Parvin.
Yes, and that's an interesting point. I think it's similar to having how you have 12-person jury. People might have different opinions on the evidence. And I think we were in a rush there because we had to have the bond hearing immediately. And yes, Judge Miller did find proof evident based on what she interpreted the statute to be. I would hope this court might have a different interpretation of what knowingly means. And this is my concern of the statute in general. I don't know what Judge Miller's definition of that statute was. I don't. It's too hard to figure out. I don't know what this court's definition of what knowingly acts. For all I know, Judge Miller might have agreed with my interpretation of how the statute reads that you're guilty even if you knowingly act. It sounds like this court disagrees and thinks, well, give me a jury instruction, but I don't know. I don't know what Judge Miller thought. That's a problem. We'd have to have a hearing on the evidence there. I'm not saying you need to overrule Judge Miller. I'm saying maybe there would be a different opinion on the facts. But really, when I'm saying I'm focusing now more on this, I saw like the conversation. Some of things come up is the big issue is we need to get to appeal on this issue. And I think the court agrees. So I appreciate the court not wanting to overrule Brown because they're not, but Mr. Myers should not be in custody while that's battle out. We should be given a chance constitutionally on this argument. We've made a very powerful case. I think the court acknowledges we've made a powerful argument. This should be fought out on a special action. And I think the Court of Appeals definitely will take this one, Your Honor, as a first impression.
He's so confident.
Videos, he's so much as just, goes on
Very.
social media whatsoever, does anything. Back in there he goes. I think that'd be fair.
Which,
Mr. Stiles,
I mean,
it's
when he's talking about the strictest of, pretrial
special action, as we
stuff,
all know,
he's already,
the Court of Appeals takes the
he's already violated
It
him.
was a long process that he would sit in jail while this First Amendment issue is being hashed out.
Your Honor, Mr. Myers made a choice. He was out on release on the first case. He was released to pretrial services. He was out. What
That's
he
not me
did is
buffering.
he immediately
It's the,
he goes home
live
and then within that weekend he goes and he does the same conduct again. He keeps doing it. So he doesn't get to just keep violating the law while he's on
Allegedly.
release and get to be out in the
Allegedly.
community. That's what this law is designed to do. Is the Constitution has, if you commit a new felony while on, there's a standard given to the state in order to be able to prove that. The state put on the evidence. It's the same evidence that would be presented if the court kept having the hearing over and over again. It's the exact same evidence. What the defense is asking for is just for this court to basically just review Judge Miller's work and then say whether they agree with her or not. And that's not
Is it
appropriate.
your position that there's no wiggle room at all if you commit an offense and the state can prove it, but at this bail hearing, then the judge has no discretion that they must hold them. They even say, hey, I believe the state's case, but I think that there are release conditions that could protect the community. Even if the judge finds that, are you saying that the judge could not release a person no matter what?
Correct. So
Judge
that's
saying, tell
that's
me
under
I
the Arizona
have no
Constitution
wiggle
that states
room.
that.
Tell
and
me.
then even under Rule 7.4 and talking about the procedure, it talks about if the court, so it's under E, if the court makes the findings required under 7.2 B1 or B2 to deny bail, the court must order the defendant held without bail until further order. It doesn't give a discretion.
Must.
It's a must.
Not forever. Calm down. I'm going to
Must.
There'll be a further
calm
order.
down. I have enough to speak next.
Mr. Myers, just let her talk. She just signed a statute, okay? Just a
So
rule.
why don't we just go to sentencing?
Calm down.
I mean, I'm guilty of a felony. They're saying. They're saying I've been found guilty of a felony while on release, so I just go to sentence.
So mad. He's
We're
so
gonna,
mad.
so just let her talk.
And then, Your Honor, under
Very
Rule
mad.
7.2, under right to release, when you go under B, it talks about before conviction, defendants charged with an offense not eligible for bail. And so it talks about under B1, it says not eligible based on commission of a specified felony or any felony while on pretrial release.
What rule are you reading from?
So this is Rule 7.2, and this is under B, and I was reading from B1.
Okay, hold on, let me get there. B1, okay.
It says,
And he
that the
literally has
defendant
his book
must not be
on his
released
desk.
if the court finds the proof is evident or the presumption great that the defendant committed. And under B, any felony offense while the defendant was on pretrial release for a separate felony charge.
Okay.
So there's no discretion. It is,
Not
the
true.
law requires that he be held
Oh,
without.
must
Oh,
is
no.
required. Okay,
Yes.
yeah, Mr. Parvin, Mr. Myers, just let Mr. Parvin
Must.
argue. We're just talking about what the meaning of
Must.
the words of these rules are.
So, hold on. No.
Oh
I know we're gonna
boy.
get there. So, the state's not correct.
Artie,
I mean, so the
he-
state is correct on the statutes.
Um,
Here's the problem, though, and I think the court's picking up
Blaine
on this.
hooked
Is there are different
into
interpretations of what knowingly
a
means. But we don't
phrase
know, and I don't know. I didn't ask.
of
her.
four,
I don't know,
four
and I
future
didn't get professional
orders or
instructions
four
for
more
law.
orders.
I don't know if Judge Miller thought that my
That
interpretation
phrase
is correct,
must
'cause I
mean that
believe-
he
if
can
you ask me,
have another
so,
trial.
you can get mad. I mean, other people listen, get mad at me all want.
hearing.
I think
which-
the statute says you're guilty just because you knowingly acted. I may think the statute's unconstitutional, but if I were on a jury, I would still find guilty because I have to follow the law. That's my interpretation of the statute. I would find guilty, even if I didn't want to. I'm not going to use jury nullification. All right?
I am.
That, I know you would. I'm explaining my interpretation
I
of
am.
the statute. I would still
Lane-
find guilty. I mean, I like it. I wouldn't want to. Now,
He just-
it sounds
he just
like, and that's
said
great,
he's gonna
that the
use
court may have a
try
different opinion.
jury
They think that
nullification.
the statute does
Good,
give no
good.
on both counts. Maybe this court would, find differently. But here's the problem. I don't know what interpretation Judge Miller used. Did she use the one I believe, that he's guilty? Or did he use the one that your court believes the statute says, which permits, all the evidence, and was it knowingly? I don't know. That's why we need another rehearing, because I'm not even sure which standard I'm allowed to argue now. I'm confused. To be honest, I am. That's why I filed the motion to dismiss. So at the rehearing, we could discuss what standard the court's going to use for the statute and really determine, was there proof evident of these two offenses? Because really, one was just showing public information about explaining why this was easily accessible. The other was showing, defending himself in injunction of why he's appealing, explaining law. And again, that's all I'm asking on that end. We get a rehearing because the court may have a different interpretation of what the statute means. And again, this is not something I had time to come up with because I've had to research the statute. I'm just telling how I believe. Sadly, I think it means he's guilty.
Or judge.
If I were the jury, that's how I would read it. But again, I hope other jurors can find differently. But now the other point, and this is one point I'm trying to explain to Mr. Myers here, is we have a real problem on special action. I think everybody agrees that the Court of Appeals needs to look at this issue under the new statute. And I was really hoping this court could disregard Brown and say, this new statute, I can be the first to act. I think the court is making a well-informed decision, believing that it's not my job to do so. That needs to be the next court. All we are asking, if that's the court's ruling, and it's a good rule, Judge, permit us out of custody to special action and give Mr. Myers full knowledge. The only thing Mr. Myers will be allowed to do with the computer is to help in his defense on the appeal so we can talk about it. There'll be no more posting in social media. You can make the most stringent conditions. I think I even mentioned potential house arrest, although he needs to be able to go, grocery shopping and other things. That case I've cited, the state cited, Arizona Supreme Court case that upheld this. Again, it didn't say that the court could never find a constitutional issue where release would be appropriate. All it said was the statute as a whole is valid. Similar to the state's argument, the state argued that Mr. Myers doesn't have standing and that the statute itself is valid. I disagree. I think he does have standing, but that was what the Supreme Court was saying, is that on its whole, it's valid. But then it went on a case-by-case situation. Each individual judge could review the constitutionality as applied to a defendant. And I think the court agrees in this one exceptional case, because we need to go to appeal here. There should not be a trial before this is solved, Your Honor. Release conditions constitutionally, and you could cite the Arizona Supreme Court in your ruling of why you're doing it, that you're finding in this case only, it's constitutional to grant Mr. Myers release, again, maybe on house arrest with permission to go grocery shopping, just, to leave the state's concerns. And, if this appeal takes, 120 days, a few months, maybe if Mr. Myers is doing well on house arrest for, 90 days of that, then I can file a motion to modify, and we can take him off house arrest if, while the appeal's pending. I'm just offering one step at a time.
So let me interrupt you real quick.
Okay.
Well, I would like to do some more research on this issue of whether committing offense while on release can never be bail eligible. What if we came back later in the week to continue this argument after I've had a chance to read some of these cases?
Your Honor, I start a trial tomorrow that goes for 2 weeks.
But that's not really fair to Mr. Myers, Your Honor, with 2 weeks.
Well, this.
And Your Honor, what I point out is that the defense has presented zero case law that says that he is eligible for bond following that finding, the proof evident presumption great. They have cited zero case law.
That was Lane slamming the table.
What they're referencing is a rule that says
was
may.
slamming
There
the
is no
table.
must. What I'm referencing are the rules that say it is must. And it is an offense that is not bailable. And so they keep talking about offenses that are bailable as a matter of right. This isn't a different category.
Right.
And it's there. It's in the Constitution. It's in the rules.
Here's what I'm going to do. I'm going to.
There's the Supreme Court gave you permission if you find a constitutional issue to grant relief. That's what I'm saying.
Mr. Myers, hold on.
Please let me say something.
What do you want to tell? Okay, go ahead.
7.2, she just read it. It says until further order. And then 7.4 defines the conditions that allow the judge to make that further order. 7.43, transfer to a new court, new facts,
slow down,
or
slow-
money.
slow down.
That's the conditions that allow you to make that further order. It's not statute and case law. It's literally the rules of procedure.
Okay.
7.2, you find proof evident until, must be held until further order. Well, how could there be a further order? Oh, let's go to 7.3, or excuse me, 7.4, which is the definitions of what, there's only 3 ways there can be a further order. A transfer to a new court, new facts, or the money is too high. Those are the reasons that you can get a new order. We're obfuscating,
alright.
we're being
You
around, we're talking in
why,
circles.
Mr. Myers, I'd explain
It
why.
literally says until further
Mr.
order.
Myers,
And then it says,
Mr.
here's
Myers.
how you can do that.
I think that's understood.
Right.
I'm just saying, read the Arizona Supreme Court decision where
Here's what I'm
you
gonna do.
find an individual constitutional basis to release them based on this huge appeal we need to do.
I'm going to take this matter under advisement and read those cases. And if I believe that we need to set another hearing on bail eligibility, I'll have my JA reach out to counsel, and we will get it scheduled at some point. But I want to read I don't want to rule against you, Mr. Parvin, right now, because I want to read those cases. I would prefer to just set a hearing, continue this on Friday.
Please.
But hold on. But this will give me a chance to review everything. Because if I think that we need a hearing, we'll find a time that works.
Friday does not work for me. It's the only day that does not work
Yeah.
for me.
Yeah. So, Ms. Stiles is starting a trial. We'll have to find a day that works. But I want to read all this first. There's a lot of paper in this case, and I think I got through it all, but I didn't get the depth on this that maybe I think I can get by reading the stuff more closely.
Can I ask one last thing?
Sure.
I just want to end. First of all, I think I've explained why I don't know what the definition, how the trier of fact is going to treat that. I don't know if Judge Miller agreed with my interpretation or perhaps yours. You haven't exactly, nor should you say your interpretation.
Right.
But I'm just saying that'd be something I would need to know if arguing, for proof evident. That's a real
Right.
problem. Why don't think we got a fair hearing?
Right,
I,
right.
Now, the biggest concern, I really believe, that if you review the Arizona Supreme Court decision, as the state cited it, it was, where is it? Marino versus Brickner.
That's in their response?
Yes, that's the one approving the statute. And what it left open was the opportunity for a court to find an individual constitutional basis as applied challenge.
Okay.
So what I'm saying, in addition to all the arguments I've made, so why I think we should get a rehearing based on whatever this court's interpretation of knowing is. It may be different than mine. I hope it is. But the biggest argument for release is so we can appeal out of custody and do this the right way, Your Honor, rather than rushing a very messy trial. And the Arizona Supreme Court has given you the discretion to find a constitutional reason to grant it as only applied to Mr. Myers, as in you would not be able to let anybody else out. But you'd be able to let Mr. Myers out because he has this appeal, which, as the court I think agrees, needs to be heard fast.
Got it. Okay.
How can I be guilty?
Hold on,
for
Mr.
bond, but
Myers,
not guilty
we
for
made the argument.
trial?
We made the argument, Mr. Myers.
All right. So then,
What about this pretrial stuff?
the last.
I hate
that's
these
the question,
lockpicking.
Mr. Myers. So
Sorry.
Judge McDonald set a trial in July on the new case, correct?
So, Your Honor, he did not.
Oh.
And
Yeah, July.
On this case, he did because I agreed to it. Mr.
July
Myers
21st.
agreed to his. But I'll say one time.
Yeah, on the new
so
case.
we were trying to get the trial set, and then there were all these objections to
Don't talk.
trial being set. And so I don't think anything's happened.
Said it.
Okay. I saw a minute entry though.
Said July 21st.
Hold on,
Literally
hold on.
said July 21st, and then he
Okay.
said we could always move it up.
Okay, hold on. So in the hearing on the 15th.
Background, Artie. He wants trial to start next week. It is not going to start next week. Obviously, I mean,
He's
Ms. Stiles
only
has
the
a
one that
2-week
envelope.
trial.
Because I
But-
had trial issues I wanted to talk about
No.
first, and he said in that one.
That,
The
no,
minute entry isn't
not going to happen, buddy.
clear, but I think the intent was that the second case, we'll call the Parvin defense case, that was set on the 21st.
Yes,
That's in the minute entry.
it was.
Your Honor, that's what we were trying to do. And we were trying to get the cases set for trial. And then Mr. Myers kept objecting to trial being set because he wanted trial set much sooner. He asked for it in a week.
In my case.
And
Okay.
so that's how this got. But ideally, we're going to consolidate the cases, but that's a different.
Mr. Myers, just let her talk. She's giving her,
It's in circles.
but you have to let her talk and then you get to talk. Go ahead.
So
Sorry.
the reason why we're
being
not taking up the
childish.
motion to consolidate is because Mr. Myers says.
But he's
two
acting
different
like a
things.
child,
One, he
so
says he
I'm
wants
matching
a bunch
energy.
of different trials to
Very
take up the
much.
separate issues because he's said that there's going to be many, many trials of, with the different counts.
No.
Which
That's
sounds-
not-
No, just let her talk. No, just let her
I
talk.
think-
You'll get a
let me-
chance.
I know, but I want to clarify because
will,
your
because
argument is incorrect. What I was saying is appeal, like a new trial, like post-conviction, remanded for new trial,
All right.
not different charges, new trial. That like we'll have the first trial, and then if it gets appealed and sent back for a new trial, we'll have a new trial.
Okay, all
Not
right.
severance.
So have you filed the motion to consolidate yet?
I have not. So we are dealing with an issue where we've got Mr. Myers is representing himself on one, Mr. Parvin on the other. And then the motion to consolidate is dealing with both those things. I want to make sure, one, that he understands what that all entails, a motion to consolidate.
I'm about to do that in 5 minutes when she's done talking.
All right, hold on. Go ahead.
So that was the issue, is because I've heard different things coming from him. So I want to make sure he understands, because sometimes the language he's using suggests that he's wanting a motion to sever counts.
No.
And then another thing says he's wanting to
Okay.
join them. And that's why there's some confusion there. And then also when we were in that hearing to set trial, then it was getting separated out. Like, he wanted them separate and one needed to happen before the other. And so I think Judge McDonald, he was just coming in to set a trial, and then there were a lot more issues going on than he was necessarily prepared or informed to be able to deal with.
Okay, let me ask Mr. Myers, in the second case, the newer case, Are you going to ask to represent yourself?
Well, we wanted to see what happened with the motion today, right? Obviously, so our plan was hear this motion, right? Mr. Parvin filed a great motion. We're going to see what you rule, right? And then we got to have, put our heads together, like, okay, are we going to appeal? It's like, if you grant it, obviously the case, dismissed, whatever, right?
Right.
And so then it's like, we don't need to have a Feretta. We don't need to set a trial because there's no trial because the case got dismissed. And so that's kind of like why we're waiting, trying to get this settled as fast as possible, the motion for that, right? And then now so then it was like, well, what's that leave us? That leaves us with the remand, right? Which I please grant an extension on that one too.
On both cases,
Yeah.
yes.
And so then it's like, okay, what's our next strategy, right? Okay, do we want to do the remand or the special action? But based on this, we're going to do the special action. So it's like, okay, my thing is basically, once we get, like, I know you said that, right? 'Cause I take what you say serious. You said, we're not going to go back and forth. He is my lawyer. He's not, you know what I mean? What I'm saying is obviously I can't do the special action from jail, right? So we're hopefully going to address that. But, now that adds another thing in, like, okay, well, today, we were going to, if hopefully you get dismissed, then now it sounds like we're going to do special action. So I'm going to have to keep him on a little bit longer. But then it's like, okay, that'll continue the trial date. You know what I'm saying? I'm willing to waive the speedy for that, right? Now, if then he would still be on there, right? And then once we would have come back, the special action would get ruled on. It would either, granted, firm, send back, you know what I'm saying? Then we'll be back in here, right? And then so it's like at that point, then once he runs with the special action, then it's like, okay, well, what else is there to do? That's when I would take over, like, because you get what I'm trying to say is, like, I'm going to be the one that questions Shannon Walker under oath. I'm not giving that right up under any
There.
So that's
I'm going to be the
that
one
way.
to question
So
her,
that's gonna
the
happen.
victim.
So that's why I want to
He has
consolidate
said
under
that
13.3 for
repeatedly,
judicial efficiency
and
interest
it
of
makes
justice.
my blood
Rachel
go
said at the
cold
couple
every
hearings ago
time.
when you were here, oh yeah, we want to
Yep.
consolidate, and I said I would stipulate to that. And then I heard it with my own ears. Last hearing with the Judge McDonald, the judge asked her, will you please do a motion to consolidate to help the court do, resource the scheduling? And she said no. That was before the hearing. That was off the record 7 minutes before the hearing started. So for her to come in, this is what I'm saying, she talks in circles. Then she said, well, no, I didn't say nothing about sever. I said, if I don't get the right to represent myself, then it's going to be a new trial for failure to, like, ineffective, remanded back. That when I said get through the first trial, it's so that if post-trial, post-conviction sends it back for a new trial, or there's an order under 20 or whatever the rule, for a new trial, by you, you know what I'm saying? When I said a new trial, I didn't mean sever. No, I mean, I want them all in one, consolidated, but I don't know how that affects him being, doing the special action.
May I say something?
So it seems to me that I don't want to set a trial date today where we have two separate trials, because it may be that everyone wants them consolidated. You want Mr. Parvin to continue to represent you
Right,
to do an
for the
appeal.
special action, right?
So maybe if we set the pretrial conference out for a while, and then maybe you'll get to a point where
But there is a July 21st already, right?
there is, it's on the calendar.
That's what I'm saying. So that's why, because that's what I brought up. I said, well, how can, it's hard to, under Rule 8, you can't just, you gotta have extenuating, so you get what I'm saying. Under Rule 8, you can't just be like, all right, we're gonna check,
May I say something?
but he
What
said
I'm
it should be done
saying.
sooner without violating.
I'm
Rule
not-
You
8.
get what I'm saying, Artie.
Your Honor, I can tell you my forte is motions and appeals. I enjoy doing it. I'm proud of my motions. I think it's gonna be a great motion for appeal, and that's what I'm focused on. I think that's the heart of this issue. Mr. Myers informed me that in the event we can't do motions, he wants to do the jury trial himself, and he has every right. He's also does some training, paralegal training. He knows he's done trials himself. He's competent. He wants to do this if need be. I don't want really a speedy trial. Mr. Myers does.
If
But
I'm doing
hold on, I'm not explaining. I want to focus on this. This needs to be handled by the Court of Appeals and the Arizona Supreme Courts. But obviously, free for all. I have no idea what's going to happen. But what do we have to lose? That's why the argument is, if Mr. Myers wants me on this case, if this court wants me to remain on this case,
Yeah.
grant the constitutional.
So he's basically like, look, man, I'm just here for the appeal and just along for the ride at this juncture.
Case I gave you
Yeah.
for release conditions, and we appeal out of custody. And again, offer the most stringent conditions possible and warn Mr. Myers that if you mess up even one time, you're back in there pending the whole appeal. And that's the way I'm on the case.
And he
We'll
gets
do
a
this
dirty
without a
look
mess of
from
trial, without
Lane
all this being
every
heard.
time he says
That's the
that.
fair thing to do, Your Honor. I will end with that. But again,
Okay.
can that make sense?
Can I add something to that? I wanted to say that the reason I want to fast and speedy trials is because I'm sitting in jail with no bond.
Right.
You know what I'm saying? So if I'm out on bond, we can take 2 years. You know what I mean? She can have her little settlements and all this kind of stuff. That
the appeals court can get it right then.
But if I'm sitting in jail with no bond, I want it as fast as possible.
Understood. So let's reset this. How about when is your trial over, or when would you have time during your trial? What's like the dark day for whoever's trying your case?
So his dark days are Mondays.
Okay. So
Next Monday.
Next
how
month.
about we could do like Monday, May 19th? Monday, May 12th, I have a lot already, and I know for some reason I have a trial set on that day. I don't know why. It must be someone else's case. But the 19th.
So I have, just to be clear, so it's this week and next week that I'm in trial. After that, I'd be open to other dates as well. So it doesn't have to
That
be.
hampers me
Hold
from
on.
filing like the remand and stuff because that's going to exclude. Like,
Well, we're clarifying. You might, again,
I can put all that stuff.
we'll get a ruling on whether the court's going to consider my argument of why I can special action out of custody with Mr. Myers.
Yes, yes.
Okay, because
That's
that's
what
probably
you're
until May 19th for that. I got to get started on that.
Right.
you're saying the bond hearing will be May 19th? Or
No,
the
no,
pre-trial?
no. In the event,
We're just gonna have a pretrial conference.
Okay,
because of
okay.
these issues, about including whether you get a new bond hearing. How about Monday, May 5th? Would that work? And
That would be fine.
how about with the victims? That work?
Yes.
to clarify, will that be, if the court agrees that I should get an opportunity to argue on whatever standard this knowingly means, either at hearing or if the court agrees constitutionally we should appeal, will that be addressed before that point or on that day?
I'm first of all, I'm gonna do the research and try to come up with an answer with that. And on the 5th, we're gonna talk about the status of the case, whether to set two separate trials whether to have a bond hearing. I just going to have it kind of open-ended based on the way things go.
I guess Mr. Meyer's concern is we do want a special action. I don't think there's any. I know there's 14 days to actually I think it's more felony, but there's more. Whatever. There's a time limit of when you get appeal ruling. I know special action doesn't have a time limit, but they do consider the appellate time limits for when you need to start the special action. I'm just making a record that the court's giving the Court of Appeals basically a reason why I'm waiting, and that's my concern. Is
Yeah, I haven't ruled on the motion for bond hearing yet, which is wrapped up with your First Amendment issue.
Okay, so that would be, and if the court, let's see, well, okay, as mentioned about legal resource. Well, we'll get to legal resources. It's all part of it. Someone's bringing up about the legal
Well, I mean,
resources.
I can't just sit in the jail and suck my thumb right now. I
Hold
got
on.
some other things that we need.
I know, but we're getting, listen, Mr. Myers, I think we made a powerful
We've run out of
argument.
time.
I'm hoping that the court has considered why you should be released pending this constitutional
I
issue.
agree with that, but I still need to work the case in the, my case as
We've run out of time, Mr. Myers.
Can you please do something about the disclosure? That's all I just want to, because this is supposed
Well,
to
let me set the hearing first. Monday, May 5th at 3 p.m. for 1 hour or an hour and a half. We'll just set it for an hour and a half. That works for everybody?
Yes. And then that's going to be a determination of whether we get a rehearing or that will be the rehearing. That's what I'm trying to
Whether you
figure
get a rehearing and whether we set the cases for trial together or separately, I think we just need to address everything that we've raised today.
All right, but we could, the court agrees, and we might be able to be hearing that day or discuss release conditions. I'm not saying the court has to, but if the court
Yeah,
says
we can
we
address
don't want to do
that.
another 2 weeks after that, is what we're saying.
And Your Honor, it sounds like Mr. Myers has some issue with disclosure, so if we could try to address
Yeah.
that. I don't
So-
know what his issue is. That's why I want
So I'm going to do, so in the first case, it'll be pretrial conference and status conference. In the second case, it'll be a status conference on May 5th. Okay, Mr. Myers, what's your
you
disclosure,
have
sir?
their list, they submitted state's potential list.
No, I haven't looked at that.
You have it up there?
Is it filed or just filed? We sent to
It's
him.
filed.
Yeah, so it's the state's notice of witnesses and
List of
exhibits.
potential witnesses and exhibits. It should be filed.
Hold on.
On the 15th.
Okay.
This is very important.
It was filed on April 15th?
Wait till you hear this one.
Oh, here we go. All right. Okay, I have it up.
All right, thank you. So 15.1B1, name, address, and any relevant written or recorded statement. Plate trash right here. This doesn't come anywhere near meeting the rules of disclosure. It says there, it doesn't even say their name, address, and any relevant recorded statements for the witnesses. And then it says under their submits, their exhibits, any and all. And you've been, anytime they start the statement with any and all, boilerplate trash. So here's the deal. Under 15.1B5, list intend to use at trial. Any and all photographs. They talking about Metcalf's family photos. They talking about my baby photos. Are they talking about photographs? They need to list out all the photographs they had. Then they can say, we'll use any or all of these photographs that we have in this list. Then they're going to list, they need to list out the witness statements. And then they can say, oh, we'll use this witness statement or not. But they need to say the witness statements they have, the police reports they have, the statements they have, the YouTube videos they have, the property they have, the body worn camera, any and all body worn camera. How would I even know what body worn camera they have if they don't list it?
Mr.
Sorry.
This is a very complicated issue, actually. We're going to address this.
This is all about reason why I think the court should grant our request to appeal out of custody, Your Honor, because this would all be moot when we do this.
But I have a deadline to respond to them, and I have
No,
4
that can
days from now
extend-
to
that can
respond. Can you
He'll try and-
extend my rule? You know how I got to respond within 10 days of theirs? Well, I feel
Do
like
you
I'm
know
gonna file a
why
legal
he
motion
wants
next
that
week because I need
information
this
already?
exculpatory evidence.
Oh, of course,
Where's
I
the-
know.
Number 8, where's Shannon's loyalty oath? Why haven't you given it to me yet?
So that is not a motion that he has to respond to, so he
No,
doesn't have
it's-
a
it's-
time.
I have to file mine within 10 days of them
Mr.
filing theirs.
Myers, he may agree you get out next time based on this issue we get the
I
appeal.
just have to work the case.
Hold on. We're going to address this on the 5th. I
The
can't,
15 stuff, the Rule 15 stuff?
we can address the Rule 15 things on the 5th as well.
Because I need to.
We're running out of time, Mr. Myers.
Look,
It's a complicated issue.
it
I
is.
can't resolve it
I don't
today.
want you to get.
Mr. Myers,
I
remember,
understand.
if we get appeal out of custody, you
Can
don't have to worry
stop
about
talking and
this.
let me talk? Can you grant me an extension to file my Rule 15.2 B and C then? That's what I'm trying to say. I have 10 days to file mine when they file it. So I have 10 days to respond to this with my list. And I'm saying that's 3 days from now. So what I'm saying is I either need an extension to file mine, or they could say, oh, you can't use any of that because you didn't file it in time.
So, Your Honor, the state's Rule 15 initial disclosure was sent out with the initial discovery. This is just the further, because he asked for a more specific list, and so we sent him a more specific
This is not
list.
sufficient.
It's all the disclosure. We've sent him all the disclosure. He's already filed his 15-2, so he's not in violation.
Okay.
He sent me a 15-2, so he's
Shut
not.
the hell up.
What I can say is he's not in violation of anything. If for some reason there's some deadline, we would agree to extend it. So he's not going to be in violation of
That's
anything.
10 days from theirs.
And I need to join in that as well because I wasn't sure if he's representing himself or not at trial. There's going to be a trial. I have not filed a separate 15-2, but if you're joining Mr. Myers 15-2.
So noted. All right, we'll
We're
see you
gonna
back here
update
on May 5th.
Well, we got to get through. Look, I
Off
want to
record.
appeal.
This is, I need. their
K
witnesses.
Far's right. He wants to he wants to put it all out on the internet. I mean, he put
Yeah,
out grand jury testimony on the internet.
Yeah. And Dave is also 100% correct. Like even if he gets his wish and gets these like stringent restrictions, he's going to violate it anyway because he's made it painfully obvious that he has zero self-control. Yeah.
Which Lane Myers is going to show up? Because I did see one video of him in city court wearing the sparkly red, white, and blue bow tie, where he was all over the place. And I mean, that stapler was very important, and he had to staple those papers until someone told him to put it down, and he acted like a petulant child. Then at one of the hearings that I was at, he was calm, he was cogent. Before Miss Stiles could even like boot up her computer, he was offering like you heard that I don't need to I don't need to stream anything, right? You heard that I'm willing to not do YouTube. Did you hear that? And being very conciliatory. And then there's also the like the hearing for the media. He was so happy to see his little little minions dancing.
Mm-hmm.
They were making all the trouble, all the uproar, and he just sat back and watched.
Yeah, he definitely, even from other hearings, he definitely has like a Dr. Jekyll, Mr. Hyde, where he has huge mood swings. Because I remember this distinctly, that there was one hearing that we covered where he was a complete asshole to everybody and everyone, and then in the very next hearing, he was so meek, so conciliatory. It was like a complete 180 in his attitude.
Mm-hmm. Yeah.
So he apparently does have a pattern of this type of behavior, but we all see
I
how
always
he
wonder
acts
which one I'm gonna
every
see.
time he's out.
Yeah.
But the problem is every time he's out of custody, we know exactly which persona is the dominant one.
Right. So yeah, Judge
All
Metcalf,
right.
he's not an idiot. He can also. It's not hard to kind of play him like a fiddle. I have seen some master manipulators in terms of judges making sure that, a dominant personality is kind of put in check for a trial. Judge Metcalf doesn't need to try that hard. He really doesn't. It's fairly easy. You could see him trying to, are you afraid it's something that I'm gonna find, Mr. Myers? Are you afraid?
Yeah.
To set the. I'm not afraid. That took a lot of work. That was subtle. Yeah.
Well, I want to thank
I
you
will
for
be back.
dropping in. Yeah, I imagine you're going to be keeping on covering this.
I'm suckered in, man. I can't get out.
You got to do it. You got to do it.
May 5th
Yep.
is I'm going back in.
All right.
So-
Well, you guys take care. Again, Judy, thank you for hanging out with us and giving us all
My
the
pleasure.
insider info. I also need to take care of this cat because she's already tried to injure herself earlier today, climbing up the windowsill. She fell like an idiot all the way to the floor, but I'm gonna have to figure that one out. But take care, guys. I'm probably not going to stream. Well, scratch that. I'm probably not going to stream on this channel. I'm probably going to stream Oblivion tomorrow on my gaming channel. And then we'll probably see you guys on Friday, and we are it's going to be set. Kfar says he's going live in 30, so guys, check out his channel. He does some good stuff. He's got good content. But in the meantime, I'll see you guys next time. Thank you. Bye-bye.
Absolutely. You bet. Bye.